place. But was it justice served, jailing him 20 years in the case that just concluded, or he is a political prisoner, as the NPP insists? We'll unpack that. Ken Ofori-Atta makes a win in his immigration hearing in the US. Is that a shield against extradition that the country seeks to have him back in the country to face prosecution for corruption? And the mid-year budget, is it real economic recovery, genuine, or we are hearing and seeing a spin over everyday economic hardships? This is Newsfile. It's your most authoritative news analysis platform. We'll be right back.
Another week is here on the greatest of all time show. My name is Giovanni Clip, and tonight we're bringing you talent. Contestant number one, let's bring Danica. Let's bring. You did it for you.
Cut. Oh, there is a leakage.
Where's the plumber? For quality and durability, insist on Syntex pipes.
If you want quality, this be where you belong.
Strong, tough, and reliable. Your perfect match to your trusted Syntex pipe. Syntex pipe, it dey carry water, no wahala. Syntex pipe, it dey make water dey flow. Syntex, and you're strong, and you're tough.
Malaria's remedy is Lonat. Therefore, we're gonna use Lonat to recover. You have malaria?
Yes,
are you shivering?
Yes.
You got chills?
Yes.
Take Lonat. First day, take Lonat. Second day, take Lonat. Third day, take Lonat.
That's all.
Lonat scatter malaria. Lonat it scatter malaria.
This advert is FDA approved.
Hi, now let me share my wildlife experience with you at Safari Valley Eco Park.
Welcome to Safari Valley Eco Park.
Our electric shuttle pulled up, and in no time, our tour began. We were surrounded by wildlife from the moment we entered the Eco Park. We were greeted by experienced tour guides who took us through orientation and how to better enjoy the experience. Watch these animals roam freely in their natural habitat undisturbed by our presence. We saw zebras, sable antelope, brown cranes, mara, silky chicken, nyalas, Shetland ponies, and so many animals I just couldn't keep up. Our tour guides taught us so much about the wildlife, their behavior, and how to interact with them. I even fed them. We also went fishing on a man-made canal. Then we took a break to have lunch in this serene environment. All this amazing experience for this price for adults? This price for teenagers. It's a bargain. As the sun began to set, it was time to go back home, but not before dinner by the campfire. It has been a thrill of a lifetime, and I can't wait till my next visit.
Safari Valley Eco Park, bringing you closer to nature.
In my line of work, a confident smile is everything. Kale Charcoal Toothpaste keeps me on top of my game and ensures my smile is always radiant and bright.
With the tiring nature of my job, we spend several hours under the scorching sun. To keep our teeth white and our breath fresh all the time, we use none other than Kale Charcoal Toothpaste. Kale Charcoal Toothpaste. You're on a Kessie and in a kit one.
Samayo Kendini, who be here, Semetra Sapapadia to Amame Manfo, Kale Charcoal's natural ingredients, and a bomb is several buying, and Maniswing, Nesansu Mama Hotoso, a will beg you.
Kale Charcoal Toothpaste. Choose Kale Charcoal Toothpaste for anti-cavity,
whiter teeth, and fresher breath all day. Available in 80 gram and 150 gram. Grab yours today.
Kel, happy smile. This advert is FDA approved.
Welcome back. This is Newsfile, and we get to Samson Stake. And I want to say thank you to the very, very many of you that I meet on a daily basis in various places, and your commendation for Samson Stake. It's a difficult task, I must confess. It's not an easy thing to be doing, but we have a nation to build. It has to be done, nonetheless. So today, my take, the abuse of free speech, political hypocrisy, and the limits of freedom. If you log on to social media today, you're almost immediately greeted by a toxic cesspool of abuse, reckless falsehoods, and calculated insults. Partisans on all sides have turned digital platforms into arenas for character assassination, relentlessly attacking public figures, including the president and his wife, with outright lies and vitriol. Now the state machinery has swung into motion, and individuals are being arrested and hauled before the courts for their words like never before. So far, almost double the number in 2 years than the entire administration of President Akufo-Addo, 8 years. Let me be clear. As I have maintained consistently over the years, this ugly subculture of free speech abuse must end. I don't know why you can't take on the issues rather than insult elders, people. Freedom of speech was fought and won to safeguard democracy, to hold power accountable, and to champion truth, not to serve as a license to malign citizens or act foolishly. However, my stance remains unchanged. Custodial sentences and criminal prosecutions are not the remedy in most of the cases. Weapons of state power, like Section 208 of the Criminal and Other Offences Act and Section 76 of the Electronic Communications Act, should not be deployed as criminal hammers against foolish or offensive speech. The solution lies in civil remedies, robust public discourse, and social media opprobrium. What is truly bewildering? Yes, what is truly bewildering, however, is the sudden shock expressed by politicians, especially President Mahama and the NDC. I don't know why they are shocked. Shocked over this growing trend. Really? It begs the question, why the sudden outrage? The NDC and the leadership of the current government were without doubt the biggest beneficiaries of the misinformation and insult fest that characterized the last two elections. Yes, the last two election campaigns. Never once did they express revulsion or publicly rebuke their social, serial callers and social media activists who insulted, vilified, and maligned almost every prominent politician in the NPP, as well as respected traditional chiefs and elders across this country. You know exactly what I'm talking about. You cannot nurture a monster for political expediency during elections and then feign horror when it begins to bite everyone around you. In the middle of this saga, former Vice President and the NPP flag bearer, Dr. Mahmoud Bawumia, issued a press release calling on the Ghana Police Service and the Attorney General to discontinue the prosecution of an NDC organizer in Agona West, who was arrested for allegedly publishing false news and making offensive comments about him. Dr. Bawumia made it clear that he never lodged a complaint or sanctioned any prosecution, reaffirming his conviction now that the answer to offensive speech is better speech, and the answer to falsehood is truth, not handcuffs, courtrooms, and crushing bail conditions. Predictably, critics have pounced on Dr. Bawumia, pointing out that he remained silent when similar speech-related prosecutions occurred under the administration in which he served as vice president. While that criticism is understandable from a historical perspective, the hypocrisy of NDC critics claiming these current prosecutions are in the name of the Republic and therefore beyond political intervention is glaring. They conveniently forget history. Back in July 2011, when the late NPP activist, he became Deputy Finance Minister. He was my mate in Legon and became my friend. John Kuma was picked up by the police for allegedly making offensive comments about the late President John Evans Atta Mills. President Mills himself directly instructed the police to release him because he was not interested in pursuing the case. If President Mills could intervene to prevent the criminalization of speech directed at him, Dr. Bawumia is entirely entitled to disavow prosecutions done purportedly in his name. Of course, he's a politician. He can see what is going on. This is being done to attempt an equalization so that it can be said that it's not only people who are maligning and insulting the First Family and NDC politicians who are being arrested and prosecuted and put in jail, but even in the NPP, those who insult the flag bearer are also facing same things. It is my prayer that politicians across the spectrum finally digest this painful lesson. In the lead up to the last election, the last two elections, you know the people you promoted in this insult fest. You know the people you promoted who maligned everybody in this country. They respected no elder. They respected no chief. No corporate executive was spared, except their NDC. You kept quiet. You said absolutely nothing. President Mahama, most of the insult, most of the misinformation and the maligning was done in your name. You know it. You didn't pause 1 minute to disavow it. You've nurtured a monster, and now it is grown, and people are latching onto that. They feel it is okay. Please, don't underestimate what the ordinary person learns from the people at the top. They feel it is right. That's why they are doing it. Please learn the lessons. This is not how to grow our democracy. Free speech is a sacred constitutional right, but it carries responsibility. And those of you who are doing this, including journalists, you make it difficult for us, the advocates, against the repressive legislations that are being used. It is not a permit for lawlessness, nor is it a shield for foolishness. And that will be my take. We'll be right back with my guest.
Palladium Residences in Achimota isn't just an address, it's the home you truly earned. Secure your place with just a 10% deposit and choose from beautifully designed modern apartments or spacious townhouses built for everyday comfort. This is more than a building. It's a vibrant, curated community with a clubhouse, state-of-the-art gym, and an on-site hotel, all at ABC Junction, minutes from Achimota Mall. Enjoy city energy while retreating to your private sanctuary. Call now to reserve your unit and benefit from limited launch incentives, including priority unit selection, executive pricing, and flexible payment options available. Don't miss the chance to pick the best homes. Book your private site visit today. Call 050-9823-424. Palladium Residences. Live smart, invest better.
Afi 1924 enye afi bia keke na mumu abrabo ahyase na se abrabo enye bibi kesi bia na mumu niema nketo a efete se edwuma edikan akukuduro a yedisi ginaye na woni obi etu anamon abomu na se bombo emma wo ahoto te se chinia ekura yen wa abra nsu kesi bi ato empofri mu na se bibie mu no wedwuma sam ekoswe na se apomuden edi enindaso ba na akomabubu nso ewo hye fofore na se ahunjie eye emre abasobode afa hudie eni enijie ewo mue na se wabrabo mu nsem ejina wo fie eni wedwuma sem ho nso na se ye di odo ebata ne ayahwere ho a yenkredie ebeye fe.
Enterprise, your advantage.
Welcome to Sulas Enterprise, the shop that deals in industrial machinery such as generators, rice millers, water pumps, compressors, and mowers. From the smallest to the largest capacity, at Sulas Enterprise, we give you nothing but the best from the best brands such as Honda and Perkins. When it comes to our generators, we also sell mowers coming from brands like Honda, Briggs and Straton, and Oleoma. And when it comes to our water pumps, we offer you brands like Lily, Prodigy, wooden, and petroleum water pumps. We also sell rice millers for all capacities. We are located at Spintex Kakalika Plaza. Also, find our various locations as displayed on screen, or call us on the following numbers: 0243-839-463 or 0554-154-416 or 0240-541-493.
Sulas Enterprise, where quality meets affordability.
Upgrade your print game with Konica Minolta, proudly powered by SkySat Technologies. From all-in-one machines that print, scan, and copy to professional systems and heavy-duty production machines, we deliver unmatched performance. Right now, SkySat has an unbeatable offer. 1 entire year of free servicing on all Konica Minolta machines. That's 12 months of expert maintenance for new and existing customers. Visit our new VIP Print Center at Pegasus Place, Airport Residential Area for a live demonstration. Call us on 050-164-5180 or 0302-798-829. Again, it's 050-164-5180 or 0302-798-829. SkySat Technologies. Performance that delivers every time.
You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, we put Ghana first. Okay, I'm seeing all of your messages flooding in like that. But as I tell you, my take is not for commentary here in the studio. So my guests are not going to have to make any comments about it. What has to be said must be said. And for those of you who are, lambasting Dr. Bawumia at this time, remember, it was only when Bobia and Sa, Oheniba, Banye, those NDC guys, when they were arrested, that President Mahama found his voice against, these laws. He's president now. He can speak. When he speaks, it will work. Thank you all. So, my guests are seated. Please, I'm not tearing. It's the AC that's directly in my face. Samuel Atachia is lead defense counsel for Bernard Entry Boesiako, aka Chairman Wontumi. Okay, so he entered the scene at the very last moment after, date has been announced for judgment, and his previous lawyer, as you say, abandoned him. Then he stepped in to attempt a rescue, however belated. Inus Afseni is former MP Tamale Central and former Minister for Lands and Natural Resources. These are two gentlemen I have a lot of respect for because they are able to say things as they are. I remember Atachia in the Supreme Court. I've never forgotten about that. When other lawyers, were acting like they are in a messy chamber where they have to be begging unnecessarily and showering praises where it was not necessary on the Supreme Court judges, he stood in that court and said, this is not a messy chamber. This is a chamber for justice. That's what we want, bold spirit, because of course, that's what lawyers are trained to be. Gentlemen, good morning and welcome to the studio. Thank you. Right. So we are starting with the two of them, Professor Kwejo Appiagyei Etua, who is supposed to have joined us, but he's unable to join us now. When these gentlemen are done with the legal issues, we will turn to the budgets with Yawapia Latte, Fred Kwashi Awute, and Dr. Gideon Boako to look at the budget as well, asking the questions if it's a genuine recovery that the country is on, or as a minority in Parliament is suggesting, this is just some numbers, statistical stuff that is just being, pushed in our faces to mislead. Thank you once again. Now, of course, you all know what has happened in the course of the week. That has gotten a lot of people talking. On Monday, was Judgment Day in the Republic's case against Akonta Mining Chairman Wontumi, Akonta Mining, and one other who is at large, Kwame Ntwi. And judgment was given. At the end of the judgment, some monies have to be paid, and Wontumi is in jail for 20 years. If he doesn't make the money payments that he's required to make, I think a total of 600,000 if you look at it. If he doesn't make the payments, he has to do an extra 3 years in jail for defaulting to make those payments. The judgment has come under scrutiny. 35 million lawyers in the country have been talking. Let's begin to unpack it. But first, listen to some of the commentary that went on in the course of the week.
Well, as we have always been going to court as law-abiding citizens, we always go with our lawyers and we always come out of court. And so we're very confident that the two motions that were filed by lawyer Techian would have been upheld by the judge, which was to look into the constitutionality of some interpretations at the Supreme Court and also to stay the execution of the judgment because lawyer Techian was out of the jurisdiction and would be back on Wednesday. And so we were not asking for the judgment not to come on either or not, but we're stating that it be deferred to a later date after Wednesday. And the judge, Her Ladyship Kokuvite, decided that she was quite all of that and be a constitutional herself and interpret the constitution, and which is why we're asking for an appeal.
So you actually were going to court hoping that the decision be deferred to another day, except
Absolutely.
But what did you think that decision would be? Why did you think it needed to be deferred? What was your anticipation?
Because of the motions that had been moved. There were two motions that were moved. The first was that the lawyer was seeking an interpretation into the 1992 Constitution at the Supreme Court based on the issues that were on the floor of the court, and also asking for a stay of the judgment, primarily because it was also out of the jurisdiction and would be back on Wednesday. I mean, Thursday is a working court day, Friday is a working court day, next week Monday is a working court day. So any of those days could have been allowed for the judgment to be held, and also because we are aware that the Supreme Court was sitting yesterday on the matter.
What was his last words? Immediately the sentence was handed over and the prison guards took over. Did you hear him say anything at all?
Absolutely. He spoke with me and asked that we work hard to bring back the party, and we should keep him in prayers, and he's going to be okay.
We therefore call on the Attorney General to publish the state's enforcement record on illegal mining across the political spectrum. We call on the Court of Appeal to scrutinize the denial of counsel, the refusal to refer, and the veil piercing with equal and unflinching rigor. We call on the judiciary to reaffirm the threshold for constitutional referral, with express regard to the Supreme Court's own decision in the Zanato case. And we call on all Ghanaians of every party to insist that the standard which cleared Mr. Chikese's name in 2016 be demanded with equal conviction today. Let us be clear about what this statement is not. It is not an attack on the judiciary as an institution. It is a call for consistency, for constitutional fidelity, for a justice system that inspires confidence across the political divide and not merely within it. History would not remember this moment for the length of sentence. It will remember whether Ghana, when tested, chose to defend the Constitution for everyone or only for the power of the day. We choose everyone. We choose the Constitution, and we will be judged rightly by whether we meant it. Chairman Wontumi is a political prisoner.
The Patriotic Party has become aware of the judgment delivered today by the High Court, the case involving our Ashanti Regional Chairman, Mr. Bernard Ntwibo Siakon, popularly known as Chairman Wontumi. Indeed, we consider the decision of the court as amounting to political imprisonment. Indeed, Chairman Wontumi is a political prisoner. It was never disputed that Chairman Wontumi lawfully acquired his mineral concession. It was never disputed that he lawfully acquired his mineral concession. That fact was established and accepted before the court. The central question was whether that concession had been assigned or transferred in violation of the law. It is our respected view that no evidence was adduced before the court establishing any such assignment or transfer of mineral rights by Chairman Wontumi. The prosecution could not produce any evidence to show that Wontumi had assigned his mineral right. Instead, the conviction rested on assumptions and inferences which, in our view, could not amount to proof beyond reasonable doubt.
Flag bearer of the NPP to assure Mr. Ntwibo Siakon, Chairman Wontumi, that we still believe that the decision by the court was perverse and was erroneous, and it's something that he also informed Chairman Wontumi that he had instructed the party's legal team and the party's senior lawyers to also take over the case. Mind you, anything that we also do is his case, so we have to also seek his consent as well. Even though Dr. Baumia earlier on Friday had met very senior lawyers of the party the moment the judgment was handed down to Chairman Wontumi, the presidential candidate of the NPP convened an emergency meeting of party stalwarts and senior lawyers of the party to also discuss the way forward. He also did come to light that he had to also then seek the consent as well of Chairman Wontumi and also assure him of the party's preparedness to stand by him in these difficult times. Again, the presidential candidate also did inform him that in furtherance to that, he will also be making a trip to the Ashanti region to also meet the top brass of the party, and that's of his members of parliament and the council of elders and patrons of the party and party executives across the Ashanti region to also have some closed-door discussions. He appeared very calm. He was in high spirits, but he was also very upset about the judgment as well.
Right, so that's a load of commentary in the course of the week, straight right from Monday, when Chairman Wontumi was convicted, and that commentary was led in the majority by the NPP. So let me begin on this note. Very brief preliminary comments before we get into the judgment itself and begin to digest it. So, Mr. Thatcher.
Yes, dear brother Samson.
You have said that the judge was in an ambulance mood. But having read the judgment, will you admit that it is sound, though appealable?
Well, I still want to say that the judge, let me first begin by saying this. This is a very sensitive matter touching on the judiciary. So if I could make a short prayer and behave myself on this elevated platform, let the words of my mouth and the meditations of my heart be acceptable unto you, O Lord, who is my rock and my savior. Samson, let me be very honest with you. there seems to be an indecent haste to prosecute what I call political cases. Because there's a justice delivery system in which the judges are not by themselves in a hurry to prosecute people, to adjudicate matters. You could go and do an audit of the adjournment mechanisms in the court. If you do a proper audit, you see that, look, cases are treated in the normal course of events. And a judge could tell you that, look, I will adjourn this case. Some people can even, some of the judges could even adjourn, 2 months, an adjournment. Okay. So now, this is a special case. They take it to a special court. And the judge will tell you that, look, you can't go to another court and then maybe do a case whilst I'm waiting. You need to come to this court, and then we proceed with the case. What is the meaning of that? It is ministering to the generality of our people. Now let's do an ambulance trial relative to political cases. But when we come to the civil cases about land matters, the same energies these judges are using in trying to, adjudicate criminal cases, are they applied to civil cases? That if you got a very good land case, a judge will tell you, like my previous situation, come to court at 9 o'clock, and then let's adjudicate till lunch time, and then go and have lunch and come back, and I'll close at 4. Are the judges giving, their energies to the political criminal cases, but the rest of the cases which are not so, or other criminal cases, they won't give it the attention. So there is a good grounding for the position that as if the judges are in an ambulance mood to, jail people. Let me tell you something which is frightening. Justice hasn't gotten a political term of 4 years. And when some people are saying that, let's run an ambulance of a justice delivery system, then we are saying that, we are trying to placate Jubilee House. Because they are interested, together with their constituencies, that people should be jailed. So that they say, this is a very serious government. If you are very corrupt, we're going to deal with you. And guess what? That kind of frenzy in NDC and in Jubilee House should not find expression in the court of competent jurisdiction. A court of competent jurisdiction wouldn't want to care about the fact that, how many people can we jail? So they will say that we are politically consequential. No, that is not justice delivery. And this is my chief concern. So, for instance, when we said we wanted the judge to consider the constitutional matters, so I'm saying, all that you need to do is that, look, I want to make a referral to the Supreme Court. And then the Supreme Court will come out with its decision on the constitutional matters raised by counsel for the accused persons. And then that should be the way I should go relative to the decision I've given. Guess what? The decision had been put together already. The constitutional matters and even the motion to move them did not minister to the judge at all. And the judge had the judgment written out before, we look at the issue of the motion. What is that ministering to everybody? Now look, I'm ready to, do what I want to do, and I will not be persuaded by any constitutional matter. That leaves much to be desired. So there is a serious grounding for the proposition that judges who have political cases to deal with are in an ambulance mood, and that is not the rule of law.
I ask about the substantive, the outcome.
Well, with the greatest of respect, I wouldn't want to pretend that I'm in the Court of Appeal, but I'll say a few things for your consideration. Samson, it is important to come to terms with the fact that a high court should never graduate into the Supreme Court. when there are constitutional interpretation borne out by the trial. I want to stress that. And the very authorities that the judge cited condemns her own conclusion. And let me refer to the Ezanoto case that the judge, applied. If you look at page 12 of the decision, the judge cited the Mekankan case and then also cited the Duamwa case and then came to the ex parte James the case and then there's another case. At page 55 of the Ezanoto case, this is what Justice Atuguba JSC said. Indeed, in that case, the court held that a lower court ought not readily to assume that constitutional provision is plain and unambiguous. What is the intent of this? When you are said that a constitutional matter is before you, and to your mind it is clear that this is not a constitutional interpretation but a statutory interpretation, and where rival meanings have been placed on the constitution vis-a-vis the laws under which they were charged, as expressed in ex parte Akosa, the defense is asserting that the law sins against Article 1911 because the law is not clearly defined, the Minerals Act, as to the criminal matter vis-a-vis the penal consequences of those things. And that was sinned against the Constitution. Make a referral to the Supreme Court for the Supreme Court to interpret. The Attorney General says, no, that is not the case. It is plain on the face of it. Samson, I beg to submit that rival meanings have been placed on Article 19(1) vis-a-vis the Minerals Act, and therefore the judge should have left the matter to the only forum that is so preserved to interpret the Constitution. And for my part, this is a ground of appeal that the judge usurped the interpretation powers of the Supreme Court, and to that extent became the Supreme Court and interpreted matters that the Supreme Court is supposed to interpret.
You seem to suggest that the High Court judge, once a lawyer or a party triggers what they feel is a question that must go to the Supreme Court, should just fold their arms and push the matter to the Supreme Court. They have no discretion in the matter. That's what you're suggesting.
At all. Far from that. You see, because were there consequential interpretations before the judge? So since you give me just a minute, I'll just read some of them.
We'll get into those details.
Yes.
But why do you say that's not what you are seeking? If the judge has a discretion to exercise,
yes,
and she has exercised the discretion, that from where she sits and reading the provisions that you say are vague, for that matter, let's go to the Supreme Court for an interpretation.
Yeah.
And she takes the view that they are plain, they are not vague. She can understand them. She has no need to get the Supreme Court involved. Why do you fault her?
You see, from the jurisdictional perspective, the power to interpret the Constitution when the arrival means is not reserved for the trial judge.
She's not interpreting, she's applying.
She interpreted it and even came to the conclusion that it is clear. And that is a very serious interpretation because the issues before her were deeper than clear. And even at a point in time, the judge actually said the penal provision is not borne out by the law. I can show you from the decision. She said that.
I read that.
Yes, it's there. So
but she tells you that the punishment, as you are talking about,
yes,
which Article 1911 says, ought also to be prescribed.
Yes.
Whilst you don't find it in is it 99?
Yes.
99 2B.
Yes.
Within the same law.
Yes.
You find it. So
yes.
she didn't understand what you were talking about, because if you read the law in full, you find it.
It's an interpretation.
It's an application.
Because, you see, she was not applying the law as it ought. Because in the sense, when there is a criminal offense tied to a penal situation, a consequence, understand? And one in which it is not borne out by the law that this particular infraction is tied to this, what's it called, penalty, then it says against Article 1911.
We'll get into the details of that.
Yeah.
But in your own address to the court,
yes,
you told the court that if you do not agree with me to refer the matter to the Supreme Court, you said alternatively, that's the word you use.
Yeah.
That means you anticipated that the judge has the power to agree or disagree with you.
That is the way that every sensible lawyer will argue. Because there are two scenarios. Either the judge will comply with the Zanotto principles and make a referral to the Supreme Court, or the judge could say that it is plain and clear, I'm not going to refer anything. Then in the alternative, look at what I've proposed as my written address. Because something, it would be very, very, very unprofessional of me just to have addressed the court on the issues of constitutional matters and leave, excuse me to say, equally important submissions on the charges and arguments pertaining to them, unattended to. And I think that will be very, very
I'll go to Inusa. Sorry, forgive me. But a few things I need to clear with you from the very, forgive me, from the very, commencing statements that you made, confirming your earliest position that these courts, where the criminal prosecutions of the prominent cases, politically, exposed persons are ongoing, appear to be in an ambulance mode.
That is so.
And that the courts we normally know can give adjournments 2 months, as you say, and so on, but here they are not allowing that to happen because they are in a hurry.
Yes.
Is that not what we have always prayed for? That we do not have situations where cases are unduly delayed. In fact, Godfrey Dame Yeboah Dame was proposing a legislation where these criminal trials will be held on a daily basis.
Yes. You see, I've made an assertion I want to repeat. Justice hasn't gotten a political term of 4 years. And therefore, if justice is being run as if we want to have a political term of 4 years, then we have a challenge. I don't believe in undue delays. And equally, I want to argue that I also don't believe that justice is being hurried. For what? An end to placate where? Jubilee House. I don't believe in it. Because, for instance, are you sure that where a judge has not heard arguments on the need to make constitutional referral, which is, excuse me to say, at the very heart of the case, and it could turn the case one way or the other, the judge said, don't move this motion because I've captured your thinking already and it's embedded in the judgment. Do you know what that means? I have made up my mind. Don't disturb me with the law. That's what it means. And she comes around with a prepared judgment and delivers it.
Not comes around with a prepared judgment. A judgment whose date was announced in advance.
Yes.
A month or more.
Yes.
And it is the expectation of all parties, all players, that the judge will be writing the judgment.
Yes.
So writing the judgment is not sudden.
I understand that.
Right. If you say these cases don't have a lifespan of 4 years or political life cycle, some people will disagree with you. Why? Because already we are hearing that if you are not successful on appeal and so on, and the NPP wins power, Wontumi will get a pardon to be released. We saw the Opuni line of cases.
Yeah.
That took 7 years. They didn't finish. The Attorney General came. What did he do? Released all of them. Stop all those cases.
Yes.
So Ghanaians are becoming aware that that statement you made is not true.
I'm afraid they are being political to the point that they want to subordinate the judicial process to their political pleasures and appetites. And therefore they are saying that, can you aid us and hurry justice so, we jail our political opponents? Is that the rule of law? And the judges should guard against that. If the judges are in an ambulance mood because they want to appease the political, government, to achieve their political ends, then I'm afraid to say,
okay, so
the rule of law is undermined.
We'll get into the substance.
Yes.
Sir, what do you say? Your reading of the judgment.
No, first of all, I'm surprised and worried that my good friend, brother, when we were in Parliament, he gave me a book. That book still stays with me.
Okay, so he has a habit of doing that because he's a voracious reader.
Yeah.
Even 2011 thereabouts, when I was going to court, he'll be reading different books, not law books, and he would show you that this book is good, read it.
Read it.
He's handed me a couple of them.
Yeah, so you see, my difficulty is that as a senior lawyer who was involved in the case, he's offered himself to discuss the matter on TV.
This is functus official.
No.
The judgment has been rendered.
He's indicated...
Everybody can comment about it.
He's indicated his intention to appeal.
Until appeal is filed, the matter is out there for the public.
So when I came and asked him, well, will you file an appeal? He says, I'm in the process. So that's my difficulty. But let me say first of all, let me say that Wontumi is not a political prisoner. And everybody should disabuse his mind on that statement. He is not a political prisoner. Wontumi is a common prisoner. He's a common criminal. Political prisoners are imprisoned because of their beliefs. I don't even believe and think that Wontumi understands the neoliberal philosophy of the MPP. I don't even think he understands.
Oh, goodness.
Yes, I don't think so.
Answer, you should withdraw that.
I won't withdraw that.
The chairman of our...
I say that I don't think. It's my view. It's my view. And how can you say that somebody who has been held by a court of competent jurisdiction to have violated the laws of the country is a political prisoner? What beliefs was he fighting for that sent him to jail? What was his ideological persuasion that was contrary to the existing governance arrangement that sent him to jail? He could not have been a political prisoner. Why? What was he tried on in court? So, please, see, as a country of laws, and I'm happy you mentioned the rule of law. As a country of laws, in the country that is intended on ensuring that at least there is civility in our engagement, there is honesty in the way we relate to facts and issues, we should, yes, you might not agree, I might not agree, but that doesn't mean that we should label a common prisoner as a political prisoner. No, he's not. He's not a political prisoner.
You see?
Two, the second thing is that, in addition to a line of cases that the judge cited, I will draw your attention to the quality grain case. You remember, I was a junior counsel in that case. Section 179, cost of financial loss to the state. We raised the issue. What is cost of financial loss? What is the definition of financial loss? What's the definition? The penalty had been provided, but what is the definition? What activities do you do that we can say you have caused financial loss? If you set out honestly to do something, and you apply diligence into doing that, and that thing turns out the other way, not to work, have you caused financial loss? Because intention is part of proving a crime.
Because the law is actually willfully causing
intentionally causing financial loss.
Mm.
What did Afre tell us? He said, oh yes, so I've listened to you, but I'll address that in my judgment. He didn't escalate the case to the Supreme Court. He didn't.
The fact that you did not disagree with him does not mean that Atacha is not entitled to disagree with.
I'm addressing it one by one. I'm addressing it one by one.
Okay.
Now, when you raise an issue of a statutory provision, which appears, and that is, I've cited this particular quality green matter to draw attention to Article 1911.
Yes.
Which is a fundamental right of an accused person. Okay? So the crime must be defined, the penalty prescribed in law.
Yeah. Written law.
Written law. You understand? So it's a fundamental right. Now, but this is how the court treated it. Now, because it's a fundamental right, the second leg, if the court ignores it, if the court refuses, neglects to address and avert the mind to Article 1911 in arriving at a conclusion, you have a course of action.
True.
And we all know that emotional discharges does not invoke the jurisdiction of the court.
That's a brilliant one.
Yes, we all know that. Okay? It doesn't invoke the jurisdiction of the court. If you think that this is the law and a fundamental right of an accused person has been violently violated, you know what to do. And the system of justice that we run is not like one-stop shop. If you go and you don't get it, that's all. If you go to the High Court, Her Lordship Audrey Kokofitei is one judge. And that's the wisdom of the court system. When you go on appeal, they no longer trust the justice, that only one person should decide the matter. 3 heads are better than one.
That's right.
And so when you go, if again you exercise your right to escalate to the Supreme Court,
you are preaching to the converted.
Good.
You call them the 3 wise men.
Good. So
but,
you see,
Justice Sakabwa calls them
good friend.
The 3 amicus.
3 amicus. So yes, so this remedy. Now, and I read, when you filed your defense, I read portions of the defense, and I said, what my colleague is doing is right. He says, look, in the alternative, he knows that this is his argument. It's a legal argument. But that argument does not make it factual. Okay? In the event that his argument does not find favor
precisely
with the court, he wants the court to avert his mind to whether or not the essential ingredients of the offense had been proved in the trial. Again, both are appealable, are grounds for appeal. Both. So the noise that greeted the conviction of Wontumi and the indecent attempt to make it political is what I simply do not understand. Because you know that there are remedies. And
in very plain terms,
yes,
the term political prisoner does not apply at all.
At all.
Do you think that the press conference that was held that used political prisoner and the subsequent one, by that time, they had not read the judgment yet? Is that what you think?
Well, it could be so. Because the judgment was 59 pages.
Yes.
But that's not too much.
Yes, that's not too much.
Yeah.
But the press conference followed immediately on the heels of the judgment, of the conviction. Yeah. And I don't know who would have read 59 pages to go and sit down and draft a press statement. And then they pick portions. Say, Wontumi had a lawful concession. And as a former lands and natural resource minister, let me state that when a license is given to a person for the exploitation of natural resources. The exploitation must be done in accordance with the terms and conditions of the license. You can't take the license and do, because you have the permit, you then do as you please on that, in extracting the concession. So that argument that, oh, he had a permit, should not be an argument that should be advanced by people who understand the law. That it's the same thing. You have your house. You decide who must be your tenant. You enter into a tenancy agreement. You say that if a third party is coming into your house, that third party, so if your tenant is going to sublease, that third party must seek your consent. It's for good reason that you do that, because you want to determine who lives in your house. So whether there is an assignment or not, okay, what happened? Who had custody of the concession? Who was the rightful owner of the concession?
You're looking at the criminal matter as if you are dealing with a simple contract. As to whether somebody says, go and do reclamation, he has a he has a menswear that should convert into doing illegal mining, and these are matters that are born about this.
Yes. So actually, the entire conviction turns on this.
Yes.
So I'm listening to the argument the two of you are having.
Yes. So let me first of all, Samson, address this. This is your being a political prisoner. You see, when you leave all the thinking in the realm called Ghana to lawyers, you say that's backlash, because we know that what happened in the courtroom was a criminal matter, and then they have lawyers, and then they came to the conclusion.
Yeah. But let me criminal matter which had nothing to do with his affiliation with a political party.
Precisely.
Not even affiliation, which had nothing to do with ideological and political persuasion.
That is fine.
That's how.
Or political activity.
That is fine. Yeah. That is fine. So the political prisoner issue is evolving from what they call the judgment of the people. What is it? If you fetch the chairman of the NDC in the Volta reading, and then maybe, I don't know who the Attorney General is, and then the Attorney General said, look, you have been doing Galamsey matters in the face of a situation in which the nation is awash with Galamsey. I want you to understand how they also say their perspective. I'm not validating it, but that's their perspective.
Are you suggesting that because one belongs to a political party, for example, if they've gone to rape somebody, defiled somebody, and they are taken to court and they are imprisoned, we should say they are political prisoners?
Ghana is not awash with rapists.
Oh, really?
But, listen, but Ghana is awash with Galamsey. Let me make this point.
Let's put the thing. You are talking as if that those who said the prosecution conviction was political,
yes,
and that Wontumi had transformed from a common criminal to a political criminal, we're not ordinary Ghanaians. We're not.
Listen.
So, first of all, no, let's not create a narrative which seems to suggest that people outside common people saw what happened as political. As political.
No, those people.
Those who led the accusation were members of parliament.
Listen.
And the general secretary of the MP.
They are projecting the thinking of the political following. Listen, this is what they are projecting. And Samson, if you give me a minute, because this is this is just not. You see, Samson, if you did that and you fetched an NDC regional chairman of the Volta region, and you secured the buy-in of two individuals who are accomplices to come and testify against him, and given all the circumstances, and we know that serious Galamsey activities are being done by the political operatives of this regime, what other conclusion do you want people to come to?
Oh no!
That you've singled out. Listen,
you are
listen.
Again, that narrative.
No,
that
listen.
You say, first of all, again, let's go back. So you will know that we know that Galamsey is right, and on this platform we had said that one way to deal with Galamsey was to go after the big fish. On this platform, we said it, and that look, Ghanaians, immediately we go after the big people. We will be sending a signal that we will go after you if you are found doing Galamsey, no matter whose axe is God. We said it here.
So if this is your sacrificial lamb, it's fine.
No, it's not.
But let me tell you what is going on.
Again, it's even wrong.
Yes.
Again, it's wrong.
No, cancel. Let me tell you.
The evidence implicating Wontumi in this matter did not start in 2025.
Does it really matter when it starts?
Matters.
It's a packaging. Listen. So Samson, what I'm saying is that it is very obvious to some people that Wontumi has been prosecuted, given what I'm telling you, that there are several MMDCs and the rest of them who blatantly are doing Galamsey in the backyard, and they are not before the courts.
All right. So
if you want to do selective prosecution, they can come to the conclusion that you are doing political, cases via the courts.
Some say it may be too early to say selective prosecution.
Yeah.
But now let's get into the judgment. Okay. So the operation of the state entities that led to this, I'm going to get to that narrative and bring you in for you to address the first issue and perhaps the second issue, because we can agree that all the charges, you can synthesize all the charges into two. One, assignment of mineral rights without approval. That's contrary to section 14.1, which prohibits transferring, assigning, mortgaging, or encumbering a mineral right without written ministerial approval, and section 99.2b of the law. If you categorize it this way, you would have taken care of counts 1, 2, and 3.
Yes.
Then counts 4, 5, and 6 come into purposely facilitating an unlicensed mining operation, contrary to section 99.2b, which creates the penal liability for aiding, you would disagree a bit there, aiding, facilitating or promoting any breach of the act where no specific penalty is listed. So for our viewers, I want them to do this for us. Then we address the first leg of assigning the mineral rights without the minister's approval, which is required. This is how the Samurai Boy operation was done. That led to the seizure of things. By the prosecution, they say that on April 16, 2025, police officers embarked on an anti-Galamsey operation in the Samurai Boy forest within the western region. By the next day, the 17th of April 2025, the team arrested one Michael Jedu AC. Pay attention because that is coming up. Michael Jedu AC was the prosecution witness 1.
Yes.
You would hear them refer to him as PW1. Many have referred to him like that, PW1, PW1. So the police arrested him together with 28 workers occupying a fiscal structure bearing the bold corporate name of Akonta Mining Limited. Remember, Akonta Mining Limited is the third accused in this case. And Akonta Mining Limited is set up by Bernard Entwibu-Esiako and one Kwame Entwi, who is at large. The two of them are directors in this company, and they form that company. So on this day of 17th April 2025, the law enforcement seized an array of equipment and contraband. They included 25 serviceable excavators and 4 non-serviceable excavators, 8 pump-action guns, 1 single-barrel gun, and 310 AAA/BB cartridges, 5 pieces of metal suspected to be gold contained in a sachet. Normally, when you go to a place where they do gold, that's how they do it. They put the gold into some small, sachets. They also seized 4 motorcycles, 2 vehicles, water pumping machines, a grease gun, 4 machetes, and an amount of 157,000 Ghana cedis cash. Now, during their interrogation, the police who arrested these people, Michael Jedu-AC, PW1, named one Henry Okum. Pay attention, Henry Okum comes up central in this case. Henry Okum is PW2. As his employer, who directed operations on the concession. Following his arrest, Henry Okum, so because he pointed to Henry Okum, they went to arrest Henry Okum as well. Following Henry Okum's arrest, Henry Okum disclosed that in September 2024, he struck an oral arrangement with Bernard Enchibu-Esiako, who is the first accused, A1, to enter Akonta Mining's concession, that's Samra Boy concession, to extract gold from unmined portions of the concession, while using part of the gold proceeds to fund land reclamation. This is his allegation against Wontumi. Specifically, he said Wontumi asked him to plant coconut seedlings on the degraded and mined out areas. Then, when you go to the police like that, you will give a statement. So in his statement, which is called the caution statement, and his witness statement, Bernard Enchibu-Esiako, who is now in jail, admitted, he did not deny this, he admitted to granting a verbal permission to Henry Okum, PW2. But he asserted that his authorization of Okum was strictly restricted to land reclamation. He maintained that PW2's gold mining activities were unauthorized and conducted without his knowledge. This is where we come to hear how they go about it and how the court resolved it. What were the key evidence used in this particular charge? So to resolve the case, the court isolated what you call the essential legal requirements for each of the charges and evaluated the evidence to determine whether those legal tests were met beyond a reasonable doubt, because it's a criminal trial. And this is how the court went about the resolution. I think I'll skip that and have them speak so that I avoid talking too much.
Okay. With the greatest of respect to the judge, I believe that her understanding of the assignment, is self-defeating. In the first instance, that assignment is a legal arrangement, because every assignment of a mineral right should seek the approval or should have the approval of the ministers. And a former minister is here. I do not believe that the minister will approve of an assignment of a mineral right when the so-called assignment is an oral engagement. Ministers do not approve of oral contracts or assignments. What the ministers do is that there should be a clear-cut case that, somebody has a mineral right, a concession holder, and he wants to give it to another person. So therefore, the requirement of writing is very essential in this case. And guess what? This case was bereft of any writing by way of an assignment. It was a case of your word against mine. Go and work on the concession and do reclamation. Plant coconut seedlings as much as you want to do. And when there's a harvest, we split, 50-50. So therefore, if the judge should say that the mere fact that PW2 and PW1 went on the concession is equal to an assignment in law, I beg to submit that that argument is not well grounded at all. And if they went to the concession by reason of what Wontumi said they should go and do, and they did otherwise, and this is my chief concern, that if Wontumi wanted them to do reclamation and they decided to go and do galamsey, how do you impute criminality to Wontumi? And guess what? If you have a farm, you remain the farm owner, and you send hirelings to go and work for you, doesn't mean that if, excuse me to say, assign your interest in your farm to them. But the sheer fact that they are working on the land. So a worker on a concession hasn't got an assignment. The right of the concession still resides in the third, accused, the company, Akonta Mining. So I want to submit, with all respect, and I concede the fact that we are not in the appellate court, but the treatment of assignment in law by the judge, it's one of the areas that we believe a court of appeal will take a look at it.
So for the purpose of this discussion, I'm tempted to do quite a bit of reading because of the chatter and the noise that has been in the public. And please bear with me because it's important for us to discuss this within the evidence and the facts. So the judge began his resolution of this matter by admitting that whether or not Wontumi gave Henry Okum, PW2, permission to go onto the concession is not disputed because all of you agree that he gave the permission.
Yes.
The contest is whether the permission was to mine or to reclaim.
Yes.
And as you say, and the judge admits that it was not in writing.
Yes.
And there was no witness to this kind of arrangement. It's just between the two of them.
Yes.
That's why you say it is, the judge is taking the say-so of that, these witnesses. So the judge comes to page 23.
Yes.
And says, the arrangement that Wontumi had with Henry Okum is not documented.
Yes.
It's not documented. There is also no witness to the discussion which resulted in the arrangement. So there is no direct evidence on the matter.
Precisely.
This is a judge being very candid, right?
Yes.
And dealing with the facts as they are.
Yes.
There's no direct evidence on the matter. Then she says, whereas in this case, direct evidence is lacking on the matter, a court of law is entitled to rely on circumstantial evidence. Then she quotes a number of authorities.
Precisely.
Please let me read one where she says, it is quoted, circumstantial evidence was evidence of surrounding circumstances which by undesigned coincidence was capable of proving a proposition with the accuracy of mathematics. In criminal cases, it was sometimes not possible to prove the crime charged by direct or positive evidence of persons present at the time the crime was committed. So where the testimony of eyewitnesses was not available, the jury was entitled and indeed permitted to infer from those facts which the prosecution had proved. Entitled to infer from facts which prosecution has proved. Other facts necessary either to complete the elements of guilt or establish innocence. However, before drawing the inference of the guilt of an accused from circumstantial evidence, it was very important to make sure that there was no other coexisting circumstance which would destroy or weaken the inference. That circumstantial evidence had to be closely examined and acted upon only when the circumstances were such that the guilt of the accused had of necessity to be inferred, and that the facts led to no other conclusion. Then she gives you further cases. No, wait.
I think that's the Wilmington and DPP.
She gives you other cases. This is Dua. She's quoting from Dua.
She's quoting from Dua.
Then she gives you other cases to still talk about these things. Then she comes to the point.
But Samson, I beg of you, with the greatest of respect.
All right.
You see, there is a critical case that she quoted but never applied. So flowing from what you said, that is the Anani Fiajo case. Right. And then read it very carefully. A presumption from circumstantial evidence should be drawn against an accused person only when the presumption follows irresistibly from the circumstances proved in evidence in order to justify the inference of guilt. The inculpatory facts must be incompatible with the innocence of the accused and incapable of explanation upon any other rational hypothesis than that of guilt. I'm going to apply this to show.
No, wait.
Yes.
Because there's no direct evidence.
Yes.
How did she come to the conclusion that the circumstances from the witnesses that had been given was sufficient to hold that Wontumi, who was identified as Akonta Mining, because they had come to the conclusion in the process that Wontumi was in fact Akonta Mining. Akonta Mining was Wontumi, because everything he was doing, all the people who came to testify said
never been a board meeting.
They engaged with Wontumi and all, and he's the one who did everything.
Yeah.
So, number one, they find, as the witnesses show,
yes,
the guy says, I'm a small-scale miner, number one. I'm not a reclaimer. So if you say I should go and do reclamation, doesn't make sense. I am a small-scale miner. Number two, Wontumi says, I don't know that he's a small-scale miner.
Yes.
The one who says he's a small-scale miner and the one who says he's not a small-scale miner, the judge is entitled to take a view. And then it is found out that Henry Okum has actually been doing small-scale mining for years. At least it's 7 or 17 years.
Yes.
7 years. Then he asked the question. He said, Wontumi didn't give him money. If you have employed me as a reclaimer to do reclamation, you didn't give me money for it.
Yes.
How was I going to do it?
Yes.
You also helped me to procure excavators, equipment, to go and do this. What was excavators for? People are asking questions. 20, how many excavators? 50 something or so.
25
excavators. Actually, not 25, 29 or so. Because there were 25 that were serviceable and 4 that were not serviceable.
Yes.
So people ask the question, what was the excavators doing? Again, it is shown that Wontumi, on his own company letterhead, makes an intervention for security protection for the work that Henry Okum and his 28 workers are doing. What was that protection for? Protection to reclaim. So she goes through all the circumstances and says, the circumstantial evidence point to this thing.
But it doesn't, because
and
there is let
him finish.
Yes, you see, let him finish. You see, because there is another rational hypothesis which ignores to the benefit of Wontumi. And let me explain. Yes. First of all, I believe that the judge was trying to surmise. And in criminal, evidence, surmising can be your, if you like, your rational thinking, independent of mens rea. Why do I say so? I don't believe that when we are doing reclamation, you should use hoes and cutlasses. So the sheer fact that they are doing reclamation and they are using earth-moving equipment is not conclusive of the fact that Wontumi sanctioned mining on the concession. I want to say that clearly. So the machine should not give you the pictures and the imagination that Wontumi has sanctioned illegal mining. Second, the judge did not realize there's a lot of money in reclamation insofar as you plant the right crops and check out the monetary value of having a whole acreages of coconut for harvest and sale. So the judge did not even bother that there's a financial reward for what Wontumi did, not in terms of mining, but rather reclamation. So therefore, if you want to prefer one version against the other, then this is where I have the biggest problem. And let me explain. The evidence is showing that PW1 and PW2 were accomplices. They were arrested and they were brought before the CFCM judge and they were admitted to bail. Now the Attorney General, as he's been doing, in my case he's done it, trying to convert accomplices into prosecution witness. Went into non-prosecutorial bargain with PW2 and PW1 that we will let you go and you will not be prosecuted and come and testify in this case. It is clear as daylight that these people were candidates of a prosecution and then they were romanced into becoming prosecution.
Is it allowed in law?
It is allowed in law.
Okay.
It is allowed. I agree that it's allowed in law. I do not see in the circumstances of the case that PW2 who went into this bargain and now is not telling everybody that he licenses me to go and do this thing. Who say, oh no, Counsel, let me finish. Counsel, let me finish.
First of all, there was a fundamental question that the judge did not avert her mind to. Was Harry Okum a trespasser onto the land?
No.
So what is the liability of an invited person onto land? Who bears liability for that?
He went there with permission. And all of them agreed.
And the permission was not the criminal permission.
So again,
he went there with permission. So PW1, who is his employee, and the 27 others who were all there, they are there on the permission of Wontumi.
So Listen, was not a trespasser onto the land. That's
correct.
That's what we
listen.
call.
All right. Listen.
Mm-hmm. Two. So what's the point? He's not a trespasser.
So he got there at the invitation or permission of somebody. That was Wontumi.
That's right.
He did certain activities that were unlawful.
Correct.
Okay.
Because Wontumi said he didn't know that he was doing those activities.
Yes.
The concession owner was Wontumi.
That's correct.
Yes.
Wontumi Akunta Mining invited him onto the concession to, according to him, to do certain things. Herokum was doing
other things.
Yes. You know, so you are arguing that Herokum having been invited onto the land to do something and was doing some other things, Wontumi had no obligation.
There's no mens rea.
Because Wontumi says he did not know.
Yes.
Oh, the fact that you did not know, the fact that you say you did not know, does not, in fact, mean you did not know.
Of course, the judge said, you claiming you don't know. Yeah. You are the same person who called for security protection and a whole Western regional security arrangement was marshaled to go and protect these people working for you. So how do you come and sit here and say you didn't know? You never visited?
Listen.
The second thing is that when the security went there, they didn't see coconut seedlings. It's all good.
Oh, no. Please. Oh, you see, they arrested them. Listen carefully. Oh. Not that the coconut plantations are there now, but they arrested them doing illegal mining. The question as lawyers.
They would have seen coconut seedlings.
Oh,
but they didn't see
the reclamation was there.
Oh, they had planted coconut at some place.
Please, back.
No, they had planted. What I'm saying is that in their accounts,
yes,
you don't read. And we are looking at the records of the court. You don't read that when they went onto the land to arrest them, they found coconut seedlings.
They were doing the illegal mining. But who authorized them to do the illegal mining? There is a necessity for a mens rea that this individual said, go and do reclamation, and they did otherwise. Where is the criminality? But let me show you a more
You don't think the judge got the mens rea?
The mens
all the assistance that
it was not present because
they are using your equipment, they are in your own facilities, there's money there,
at your invitation and permission.
And
then let's come to
it's okay. Please, hold on.
Let me finish.
Hold on. Started with assignment.
We are still on assignment.
Hold on. And therefore, there is an alternative rational hypothesis that indeed and in fact, Wontumi said the gentleman should go and do reclamation, and they did otherwise. Now, there's a problem here in law. The problem is that when a witness who is an accomplice is testifying, the law says the judge should be very cautious of the evidence of the witness who has bought insurance to come and testify so that he's not prosecuted. And that caution is for one simple reason, that the man cannot testify against himself. And he can also not testify against the position of the Attorney General where they've signed a plea bargain. Very important. What is even more important is that the law enjoins a court that you need collaborative evidence. Something I can show you the authority.
In that, in the absence of collaborative
Sorry.
evidence.
Of course.
Sorry, let him finish.
Of course, in the absence of collaborative evidence, where you have been converted from
and we keep in mind that even the Deputy Attorney General has conceded what is in the judgment.
Yes.
But for these people, the case would not have won a case against them.
Precisely.
Bottom line, that's what he says.
Yes.
When he says that the evidences that were relied on, everything was Wontumi's own evidence, which includes his own people who were working for him.
And even
Right.
something that what is even more serious is that the Attorney General is now conceding that the judge should have upheld the submission of no case.
Really?
Yes, because he's saying that now Wontumi is being convicted on the evidence of who? Not that they produced on his own evidence. And there's no evidence that the Attorney General produced which is strong in itself, more so when you've brought in accomplices.
Okay, these comments are in the public.
Yes.
He didn't make them in the courtroom.
So
go on to where you are going.
So let me just give you an authority. He knows all these things, but sometimes, they want to ignore the law and do other things. Listen, pay regard to a very, very seminal case of Obin versus the Republic.
Right.
And the court was so strong on this matter. I think, with respect, that the learned trial judge erred in failing to direct the jury to consider whether Georgina Owusu-Afriyie was on the evidence an accomplice, where in the seminar matters are suggested as being corroborative, which in fact are not, and therefore it is in fact no corroboration at all. The conviction may be quashed on appeal. You see. What the law, and there are several. I don't want to detain you with all the authorities of the Supreme Court. But let's come out clearly with this. Apart from what PW2 said, there is no corroborative evidence that would to me sanction him to go and do illegal mining. There's none. I've perused this, 59-page judgment.
Corroborative evidence, but you have more than one person saying the same thing.
Who else said it?
PW1 and 2.
Listen, the man who brokered the deal is who?
Even their own witness they called.
Yes.
What's his name? Is it Gomashi or somebody? Yes. Their own witness they called. Ended up giving evidence that the judge used, which obviously is against them. Because he came to testify about the expensive nature of reclamation, and you cannot ask somebody to go and do reclamation without giving them money.
Listen, that is a conjecture. And yes, and it's a bargain.
That's an expert witness.
Yes, the expert witness said.
How do you expect to pay the
listen,
guy doing the reclamation?
That is their bargain, and that is not criminality. A man says
that should prick your mind.
No, listen. A man says that I am ready to go and do reclamation
because of
grow coconut seedlings, and let's share the profit 50-50. In the mind of the judge, that was a poor bargain. But the judge is not supposed to rewrite bargains in a criminal matter. And that is what is very important for us to see.
You seem to suggest that mens rea cannot be inferred, but that's not law. You can infer mens rea, and that's what the judge says. The circumstances leave.
I'm not saying it cannot be inferred. You cannot impute. You see, you are trying to say that he had a criminal mind. He's saying that I didn't have a criminal mind. Why? I never sanctioned this guy to go and do illegal mining.
Let's hear the judge. On page, what's this?
Can you let me do
Hold on. Page 28. I'm at page 28. Page 28, the judge says, in paragraph 6 of his witness statement, Henry Okun stated further, quote, I funded the reclamation works using proceeds from my mining operations on the concession.
Yes.
And Wontumi was fully aware of this fact, end quote. Then the judge says, Henry Okun was not cross-examined on this critical piece of evidence.
Yeah.
Neither did Wontumi put before the court any evidence to show that he had advanced money to Henry Okun to fund the reclamation. Thus, Henry Okun has maintained throughout the trial that Wontumi had permitted him to do two things in the concession, namely to mine for gold and then use part of the proceeds to reclaim the damaged land.
Yes.
In fact, during cross-examination, when Henry Okun repeated his claim, counsel for Wontumi and Akonta Mining did nothing about it. So this is what happened. I need to mention that. This is a question was asked. Were you able to extract some gold in your operations? His answer was yes, of course. That was my aim of going there.
Yes.
Question. And when your staff were arrested, that's the 28 others who were arrested, when your staff were arrested, they took away some amount of gold. Is that correct? His answer, yes, my lady. Question. And this gold was not from illegal miners, but from your operations. Answer, yes, my lady. Now, this is how the judge asked a question. The nagging question at this stage, following from this testimony, is why any person of sound mind will volunteer to reclaim a tract of land deep in the forest that has already been mined by another at that other person's own cost and at no cost to the other one who has asked him to do the mine, the reclamation.
Yes.
More intriguing is that this person alleged to have offered this service gratuitously is a small-scale miner with no previous experience in land reclamation, assuming without admitting that a person of sound mind would even agree to enter this alleged arrangement. Henry Okun has expressly, emphatically, and consistently refuted the claim that he ever agreed to it. Having rejected the allegation, the burden rests on Wontumi to lead evidence on the probabilities to show that Henry Okun had agreed to the alleged arrangement. No such evidence was, however, led in this case. What did you want the judge to do?
You see, even there is a fundamental error that now we leave the realm of proof beyond reasonable doubt and come to probabilities in civil cases. This is the poverty of the judgment.
No, the probability
Listen,
used there.
Counsel.
The probability used there is reasonable doubt.
Look,
the probability.
Look,
it's not proof beyond reasonable doubt. It's probability, the reason of doubt.
Counsel. I'm saying that
the arrangement. Yes.
I'm saying that there is a whole aberration in trying to raise the issue in probabilities rather than a reasonable doubt. Because the authorities are clear. The burden of proof is
reasonable doubt.
No, the authorities are clear that there is no burden. There's no burden on.
No, to display the burden of proof of reasonable doubt.
I crave your indulgence.
Doubt.
Listen. There's a doubt raised. In the sense that, look, if you do not assess the value of reclamation, and if you do not understand that you are not supposed to conjecture as a judge in trying to look at the bargains of the people, how poor the
inference or conjecture?
It is a conjecture.
It's a judge entitled.
Yes,
Mr. Atacha. It's a judge entitled.
Yes,
it's a judge entitled to also consider a witness in his whole.
Yes.
A witness or an accused who says, I employed him, but I didn't know he's a small-scale miner. The guy says, I'm a small-scale miner. That's what I've been doing for years, and he knows.
Yes.
Then, to help him to procure machinery, including excavators, okay, the question is being asked, what for? In those numbers. Hold on. Reclamation by seedlings and coconut trees. Now, Wontumi, again, sets up this company, the third accused, with Kwame Entry, right? Kwame Entry, where is he? Wontumi says, since 2021, 2022, he said he was going to travel. I haven't seen him since. Your own partner in a company, you don't know anything about him, you can't find him. Do you think the judge is allowed to disbelieve Wontumi and believe the other witnesses?
Yes, because there is an alternative rational hypothesis that does not lead irresistibly to that conclusion. Let me finish.
When he finishes, you come in.
Please. So therefore, if in the mind of the rational judge, Wontumi's tendencies are not economically sound with that amount of criminality, you should look at it critically. Is the judge entitled to rewrite the bargains of the people? And let me tell you something. There is no incentive for PW2 to speak the truth, because he has signed his insurance that go and testify against Wontumi for your freedom. What were you expecting? Did the judge place anything on oath against oath? And also, when you need corroborative evidence relative to what an accomplice will say, this is at the heart of the case. And I'm very, very sad in that. The judge was...
The corroborative evidences you are talking about.
Yes.
The judge points out to you that Wontumi and Akonta Mining, they called how many witnesses? 5.
Yes.
Out of the 5, she says 4 of these witnesses confirm that Wontumi does not do his things in evidence writing. He does it orally.
Yes.
What else? So it is oral evidence that she will use.
And that is even more serious, that the oral evidence is one of an accomplice against Wontumi. And the accomplice has bought his insurance for freedom. Who should you believe? And the law says that, Supreme Court decisions are saying that there should be corroborative evidence relative to what? The critical engagement. Now, nobody was there. It was between PW2 and Wontumi. All the other people were not there when they were doing the bargain. And one of the things that has been lost on, everybody is that, are you saying that you can't make money out of reclamation and the harvest of large-scale coconut? Are you saying that? So why are you saying that it is not probable in your thinking? And that is a very sad conjecture that the very authorities on circumstantial evidence does not permit a judge to do.
Yes.
So you started by assignment.
Don't you think, importantly, that they raise the question of the assignment, which must be evidence in writing?
Yes.
And there is nothing like that.
So what is the procedure? So you have a concession, and you want to assign rights, your mineral rights in that concession to a third party. What do you do first? You write the assignment.
That's so.
No.
What do you do?
You seek approval.
You know what is
what
that?
they are telling you in their defense. What they are telling you in their defense, that as far as this particular charge is concerned,
I'm telling you the procedure.
As far as this particular charge is concerned, they are saying throughout the case, you can see that was their defense strategy. That to the extent that there is no document evidencing an assignment, that charge is dead.
So you have mineral concession and you want to assign to a third party. The first course of action open to you is to write to the minister informing him that you are engaged in discussions with a third party to assign your mineral rights. Now that is first. Not doing that alone cannot even entitle you to assign.
So then therefore
they are saying that they did not assign mineral rights. Wontumi simply engage somebody to go and do reclamation. That's what they are saying.
Oh, then I'm trying to explain to you. They are using the technical meaning of assignment to try to defeat the argument. I'm saying that you cannot jump into assignment. The fundamental thing is, if you want to assign, and so it's right in saying that we didn't assign because you didn't write for approval to assign. It's right.
So
you understand? And they did that deliberately because it was an illegal activity that they were engaging.
How do you say this?
But it's true. First of all, you want to assign. You say that assignment must be in writing. You say that. It must be in writing.
Yes.
But because that is law. They are not the ones saying
that. He says that. It's law. But the approval, seeking approval from the minister must also be in writing.
It didn't start at all for anybody to go and seek approval.
But you don't see that it didn't
start at all.
But you didn't see that it didn't start.
The assignment was not present to go for a ministerial approval.
You didn't see that it didn't start.
Yes.
That was the criminal intent.
What was the criminal intent here?
Because you
go
didn't intend to follow the law.
Oh, goodness me. Now you should show that
you didn't intend to follow the law.
You should show.
And so you entered into oral agreements to put a third party onto the land and come to court to narrate facts which clearly is not supported by what the third party was doing on the land.
The judge said, even if Henry Okun's engagement was to do reclamation, reclamation must be done by, he should have done a certain registration or procured the license required for the reclamation.
Yes.
He didn't have that. He says, I don't have that because I am a small scale miner. I don't do this. Questions have been asked. If somebody admits to an offense like this, shouldn't they be punished? The judge says that provision, which says you must have a certain registration of or license before you can do reclamation. That law, that provision does not come with a punishment.
Yes.
So he goes free.
Yes.
They are asking you the question, why should such a person go free? Because he's admitting to wrong.
Well, after self-confessed criminals, we have got a lot. So you don't go there. Don't go there.
You've got a lot from where?
It won't benefit you. Don't go there. What I'm saying is that is for the state to take up.
Right.
That's not for me. And so, if a person commits a crime, the interest of that person against whom the crime has been committed, if it is an individual, is contaminous with the interest of the state. And so, the state must decide whether it wants to go after that person. That's why we don't have private prosecution.
That's why you talk about selective justice then.
That's why we don't have
Let me get accomplices to come and testify against the chairman of MPP in Ashanti region.
Professor Apieje Etua joins us, but I'm coming to you. When the judge says in page 54,
yes,
what I believe many have not paid attention to,
yes,
she says, page 54, the very last paragraph,
yes,
she says, the very absence of documentation is not a defense, but part of the informal and undocumented pattern of dealing this court has found to be the true character of Wontumi's conduct of Akonta Mining's affairs. A finding that a right holder cannot use his own default to defeat. So when you say I need evidence written, she says, let me read it again to you. She says, the very absence of documentation is not a defense.
It's modus operandi.
But part of the informal and undocumented pattern modus, which Wontumi's four of his own witnesses confirm. It's part of the informal and undocumented pattern of dealing that this court has found to be the true character of Wontumi's conduct of Akonta Mining's affairs. A finding that a rights holder cannot use his own default to defeat. So the fact that you don't have a document, you can't use it as your defense to defeat the fact that you have in fact done the thing. That's what she's saying.
In fact, I find it a bit weird to suggest that if you have a concession, you cannot give it to individuals to work on it. Like you yourself as a company should be working on it. That is what we should bear in mind. But if you can. It's here.
Where?
Yeah, I'll show you.
Where?
Yeah, what the law says. You see that you can do things reasonably necessary associated with the mineral right. Yes, is that in fact the judge quoted that?
Which one?
Let me get it for you.
I think he's talking about section 46.
It's there.
But did that come up in the case? This is belated that people are, putting up section 46.
No, even putting a wrong interpretation on it. You read it, section 46.
Let me get you.
Assign without authorization. You can't.
You see, there was no assignment in the first instance. You see, Counsel, let's be clear on this. Let me try and
put the interpretation.
Let me try and get you. A very important dimension. I found it very weird that if you're a concession owner, you can't do what is necessary to actualize. What you're supposed to do.
That is bringing people to do galamsey on the land.
No, he didn't do that. He didn't say that they should go and do galamsey on the land, but you can do what is necessary. Yes.
Actualize that.
Yes.
That's the terms and conditions of your license.
Of course.
That's not.
If you got hirelings to be working on the concession, are you not? Is it not necessary to actualize you having the right to go on the land and do your mining?
It's a contorted interpretation.
What's contorted interpretation?
Okay, so I take it that you are waiving reading section 46 because it didn't actually come up in the case.
It's true.
It is now that it's being raised. Yeah, now I'm going to bring Professor Appiagyei Etua for his very brief comments. He couldn't join us earlier.
Yes.
His very brief comments on the way the judge went about coming to the conclusion. And I will do that once again with reading something from this paragraph. And you can see that I'm deliberately doing this because there's been a lot of chatter in the media without specific references to the content of the judgment. The judge says, it has not accepted Henry Okun's account uncritically or his oath alone. It has tested, that is the court, has tested that account against Wontumi's own witness statement. The Wontumi's own investigation caution statement, the unchallenged, uncontroverted evidence that Henry Okun, in fact, extracted gold from the unmined portions of the concession. The equally unchallenged evidence. So remember, she's talking about something. She's saying that, don't say I have listened to these people without being critical. She says, I've been very critical about it. And I have tested his oath, his evidence against Wontumi's own. Things he has admitted, his own witnesses have said. And she says, the unchallenged and uncontroverted evidence that gold was extracted from the concession.
Yeah, they found gold.
And then equally, the unchallenged evidence by Henry Inkum that he funded the reclamation exercise from those very proceeds with Wontumi's knowledge, and the absence of any evidence beyond bare assertion that Wontumi ever advanced funds. So it is shown that Wontumi never ever advanced any funds for the reclamation. Then she says, verified Henry Inkum's claimed line of business that he's a small-scale miner, or supervise the site to ensure that only reclamation, remember, Wontumi says he didn't supervise the thing, and no mining was underway. He didn't ensure that this was going on. It is that convergence of independently tested circumstances and not Henry Inkum's word alone upon which this court's findings rest. The submission is accordingly rejected.
Yes.
Professor Appiagyei Etua.
Okay.
Let's hear you. Hello, Prof.
Hello.
Yes.
Thanks for having me, Samson. It's a pleasure to be on the platform, and apologies for coming in late.
Don't worry at all. Emergencies happen to all of us.
Yes. So, having listened to, well, not much of the discussion going on, but having had a time to read just portions of the judgment, I come to the conclusion that clearly this was a decision that was fairly decided by the courts.
Really? Wontumi is not a political prisoner?
Not at all. I think the whole idea of a political prisoner is totally blown out of proportion. There is no connection at all between what Wontumi did or what he has done and the claim that he's a political prisoner. If you're a political prisoner, it means that you have not committed any offense, but you have come up with some thoughts and ideas that challenge the powers that be. And therefore, you are speaking truth to power and you are challenging orthodoxy. And you are making some claims on human rights grounds to promote democracy and human rights, which therefore does not accord with the position of the government in power, and therefore you are being silenced. And that is where, whether they put you in prison or they try to gug you or they try to force you out of the country into exile, that is where you can talk about somebody who you can term as a political prisoner. So there is no way that we can term Mr. Wontumi's case as a case of political prisoner, not in any sense at all. And I think NPP went below the belt by drawing that conclusion. In my opinion, the decision was fair and square. It is a very good decision, and the judge took time, I think probably because of the political context in which the decision, the case came about, that she made sure that all the evidence is tested, and the decision that she came to is, I think, the right decision that should be applauded.
Like Inusaf Husseini here, there are some members of the public who are asking questions. 29 excavators found on this place and seized. What are excavators doing in reclamation? But you can't do reclamation of such a place that has been devastated by mining without excavators.
Oh, definitely, you will need excavators one way or the other. But it is not just the excavators. The overwhelming evidence indicates that some work was going there, which clearly showed that there was no authorization to mine a concession, and the issue about the evidence given that there was some work going on to reclaim the land, where in actual fact, the work that was being done, the person is not being paid. So how do you get paid? You have to mine and do the illegal mine in order to get money to pay for what you are doing. And so putting all this together, I think it's clear that what Wontumi was doing was done in violation of the laws, the very laws which, interestingly, the then NPP government came to enact or to amend to make sure that people do not violate the laws of the land as an attempt to help protect.
But Prof, the question that is being raised is that this is criminal prosecution. Proof must be beyond reasonable doubt. Of course, we know the rule that beyond reasonable doubt, as the judge herself, is not unminded of, says it is not beyond all, beyond a shadow of a doubt. Proof beyond reasonable doubt is not the same as proof beyond a shadow of a doubt. But where circumstantial evidence is required to convict a person, the argument is being made that the alternative could also be plausible, that he's simply unaware, despite all the information that suggests that he may be aware.
Yes, the issue of circumstantial evidence at a point in time it becomes very critical to resolve that in order to ensure that justice and fairness in the decision is recognized. And I think that with what the judge went through in coming to the conclusion that it points to a case of violation of the Minerals and Minings Act, I think it rests on solid grounds. And so for that matter, I think that we cannot fault the judgment in any shape or form. If you're looking at circumstantial evidence, you have to put a lot of evidence and factors together, and before you can come to the conclusion that this is, there's no other alternative decision or conclusion you can come to. Yes, it is possible that you can look at it from other angles and see that it is possible you could have arrived at a different conclusion. But the overwhelming evidence seems to support the view that the judgment was fairly done. The judge did a thorough job of ensuring that all the critical pieces that needed to be looked at were looked at. And for that matter, on that basis, the conclusion to me is clear. That
but Prof, I have a problem here, Prof, with the greatest of respect. You see, when you touch on a case in which the judge has pronounced that there is no direct evidence, and therefore let me go into the area of circumstantial evidence, you know, all the authorities are very clear that you shouldn't come to a conclusion that is guilty if there is an alternative rational hypothesis.
Yeah.
That's not a federal case. So therefore, what I'm seeing in this judgment is judicial, evidential, infailing. The bargain does not make sense to me.
The judge's view then is that the alternative is not convincing. That's the law.
No,
the alternative is not convincing.
That is the point.
It's not that convincing. It should lead irresistibly to guilt. So I'm saying that if a man goes to do...
Yes, but the alternative that you are proposing is not raising doubt in there.
The alternative hypothesis is consistent with the innocence of the man, that I told you to go and do reclamation, and you did otherwise. Is it not a rational alternative hypothesis since the judge has made a finding?
The judge is asking you a question. The judge is asking a question. Will a rational man commandeer a whole regional security to go and protect somebody when he doesn't know what the person is doing?
Because of the gangsterism in this mining arrangements. Why not?
Mining.
So you think it's only in Ghana that you need protection?
You said he was not doing mining.
Yes. So you think it's only mining that you need protection?
The judge averted her mind to the fact that if someone is doing reclamation,
he doesn't need protection.
He doesn't need security.
You have been told by some other commentators that you can't fault this judge. Long before this judge came to handle this case, the Akufo-Addo regime itself had flagged Wontumi that what he was doing there, he was not doing it with approval. In fact, if you go to a 2019 judgment by Justice Ejie Frimpong, it was a civil case.
Yes.
But Wontumi was found to be doing illegal mining. He had commandeered 100 Chinese nationals doing work there. Was it 10 or 100? Then in 2023, another court, still in Second D, in Akonta mining case against Samatex, still finds that Akonta mining was there doing mining when he didn't have the right to do the mining.
Yes.
At the time when only he had a prospecting license, he was doing mining.
You see,
the people had complained over a long period, since 2012, 2013, and so on.
You are not permitted to backdate a crime. And let me tell you what is very critical.
The crime doesn't run against
you see, you are not permitted to backdate a crime.
Doesn't run against
the evidence before this honorable court has not gotten anything to do with the past.
I agree with you.
No,
That's why I didn't bring it up.
Please.
Samson, in the 2013
we need to take a break and move to Kenoforiata's success.
Yes, but I just want to say that, I just stayed away from that case. The 2013 case, I was the minister.
Yes.
You see, don't import.
Sued the Attorney General for $43 million.
Please, don't import past issues into this case. We have a good case right now.
But are you concerned that in two different judgments, 2019, 2023, the courts found as a matter of fact that Akonta Mining Services, Bennett and Chibuesiaku were engaged in illegal mining? Where? Samra Boy.
I am very much concerned. Illegal mining is not what I will bless. But what I'm saying that right before this judge, it's not these imported past events.
That's correct.
There's a recent...
That's why we are not talking about it.
There's a recent case in which a man says, go and do reclamation. And the man does illegal mining. All right. And let's say...
I agree with you. We don't want to go to the past. So that we
want to impute criminality to the man.
Okay, thank you. Prof, maybe your final comment on this before we take this break and return to the matter of the Kenoforiata. Atachan believes that of course, many lawyers have said this is a good grounds that he will be going on.
Yeah.
Believes that, the preliminary point that he raised, that the provisions were not clear enough in the prescribing the punishment, and therefore asking the judge not to give a judgment but to hold on and refer the matter to the Supreme Court for a determination under Article 132.
Yes.
The judge should have done that, and the judge disagreed. What do you say about that?
I'm sorry, the line has been buffering, so I'm not able to hear you very well.
Yes, Atachia said that the judge should not give a judgment. He should wait.
Okay.
Stay the judgment and refer Section 14.1 and 99.2b of Act 703 to the Supreme Court under Article 132 because the provision vesting that's the provision that vests the Supreme Court with original jurisdiction over genuine questions of constitutional interpretation and requiring that lower courts must refer such issues. He argued that the statutory provisions that were used were unconstitutionally vague under Article 1911, right? And the judge said they are clear enough for her. She moved on.
Yes, I think I agree with the judge because even though the issue of, I think, punishment was not clearly stated in that particular law, it was referred to in another law, in another act, and which I think that it solved that gap that counsel Atacha is trying to argue that because of that, on that basis, it should be referred to the Supreme Court for interpretation. So I think that gap, which would have called for that interpretation, is filled by the reference to that law, which I can't remember exactly what. So in my opinion, that should end the journey to the Supreme Court.
Okay.
And should end the matter there.
Okay. Actually, she relied on a case that said that a trial court is not obliged upon the mere say-so of a party that a question of constitutional interpretation arises to down its tools and refer the matter upstairs. My cancan, he just referred to. We'll be right back.
She didn't apply as an author who says that do not graduate from a high court to a Supreme Court.
Yes, I said I was taking a break, but you are appealing this at all costs, right?
Yeah.
When are you filing the appeal?
Next week.
Yeah,
we should be able to do that.
Yeah.
Yes,
and when you file the appeal, you will file bail pending appeal.
Certainly, we'll do that. He will do that.
So you are hoping that he will not be in prison for a month before,
I'm hoping that the judges should apply the law, and then we could get him out and contest the appeal. Yeah, because bail pending appeal is simply saying, look, if the appeal should succeed, that is it.
Okay. So if this doesn't succeed, it means Wontumi is going to be in jail for, if he conducts himself well in the prison,
good behavior,
he will be in jail for 13 years and 4 months.
On good behavior.
He will get a dash of 1/3 of the sentence. That will be 6 years and 8 months. But that is if he pays the cumulative 600,000 Ghana cedis fine that has been slapped on him and Akunta Mining. If he doesn't pay that, he goes to jail he spends another 3 years. But the prison calculation is different. We'll take a break.
Yes, we didn't address the critical issue of the sentence because as a first offender, Leonard, you should know that if you took him to 20 years, I thought you even consider the minimum,
which is 15.
You see, so these are also feeding frenzy.
This one you shouldn't complain.
No, you are talking about
you were part of the majority who escalated it from.
No, you are talking about deterrence, and I'm saying that.
What I'm saying is that Attorney General Gloria Akufu came to Parliament with an amendment to Act 703 and proposed 10 to 15 years. When the bill landed in Parliament, Constitutional, Legal and Parliamentary Affairs supported the Attorney General. When the report was presented to Parliament, the majority led by my good friend Chairman Semusu said the 10 to 15 years was small and that we should escalate it to 15 to 25 years.
That's water under the bridge. I'm saying that. You said.
I remember President Akufo-Addo.
Yes.
He actually gave a statement at the time when he was waging the campaign against Galamsey.
Yeah.
He actually made a statement that we couldn't trust the judges.
Yeah.
At the time, the maximum was about 3-5 years or so. And he said we couldn't trust the judges. Yeah. And there was even opportunity of a fine.
Yeah.
So you see now the new law, as amended under your regime, is that it's not either or.
Yes.
You get both. You get a fine and you also get jail.
Get imprisonment.
President Akufo-Addo said some of the judges could not be trusted because they were taking money and giving them fines to run away. So this is how come you did this way. And then you increase the punishment.
You say we even do not trust that we will get to that situation where you will send somebody to court for conviction. So instead we should shoot them on sight.
Shoot to kill.
Be that as it may, the judge said something which you should pay attention. He said deterrence. And I'm saying that you cannot use Wontumi as a sacrificial lamb to arrest Galamsey in the realm.
They have not used it.
So the deterrence
that apply the law.
No, the deterrence is as a deterrence. Therefore, I'll give this by 20 years. The people who are taking guns to shoot others, are they deterred by this?
So as I understand, part of your appeal will be on the sentence too.
Yes, indeed.
It's too harsh.
It's very harsh.
But the least you get is 15 years.
Yes, that is fine. But I'm saying that is what the law requires.
Some people are saying you were not in court. You should have been in court. If you were in court, maybe things would have changed.
I couldn't have improved upon the law if I were in court. Because, I mean, with the greatest respect, the judge was ready to give the decision. And the judge said, I mean, she will not defer the decision. And that my motion it's deemed read. And it's going to incorporate, I mean, all these matters in the judge.
Right.
That's what she did.
Right. Thank you very much. So since 2020 and 2025, illegal mining prosecutions, convictions we have secured so far, 163 convictions.
Yes.
146 are Ghanaians, 2 are Nigerians, 3 are Chinese. Only 3 are Chinese. Another 3 are Nigerians, 4 are Togolese, and 5 Burkinabes.
So something.
We will be right back.
Deterrence is staring at us in the face. Is it going to deter anybody?
It will.
Let's see.
Yeah, it will.
Let's see.
From the heart of Africa we stand, building dreams across the land. Every step we take aside, helping you rise, taking you higher. Strong as a group, close as a partner. Bank of Africa lifting you higher. African Bank with global reach. BOA make your future glow. Strong as a group, close as a partner. Bank of Africa lifting you higher. African Bank with global reach. BOA make your future glow. BOA, we go there for you night and day. Strong as a group, close as a partner. Bank of Africa lifting you higher.
Bank of Africa, as strong as a group, as close as a part.
Yes, next. Hey, Nadia Benson,
Me didn't tonton. Mr. Femi Kakalika, just call me cockroach. Now, Mr. Femi once now.
Hey, it's you. Impruka. Yeah. Captain Mosquito, double the action.
Sasso spray. Mr. Femi Sasso quell. Yeah, go to my
tom preko.
Day by Day exists in lotion, cream, soap, and more. Day by Day has 4 fragrance range.
Discover Willow Lane in Sakumono, one of Ghana's most prime community. These expertly designed 4-bedroom homes feature a private elevator, 4 ensuite bedrooms, private balconies, walk-in closets, and a gourmet kitchen and a maid's quarters. Perfect for families, executives, investors, and retirees. Our community offers a swimming pool, playground, and 3-tier security for your peace of mind. Experience the ultimate in comfort, convenience, and community here at Willow Lane, Sakumon. Visit waylead.org or call 0240-111119 or 0308-040500 to book your tour today. Waylead, your trusted home builder.
Having gone to Translight Solar, really, it's been one wonderful experience. Since the system was installed in my house, my daytime could be somewhere around 20 cedis. And so I've seen a marked reduction in my bills. And because of that, I am not paying as much as I used to do when I was relying solely on the national grid. My house has now become the city on the hill. With this current doomsaw, anytime my area is off, my house is well lit. Everything is on point. And I can get as much as 13 to 14 hours with my ACs and everything working perfectly well. So I can say, as for Translight, they are the truth, the way, and the light. You have to speak to Translight today. In fact, speak to them now, right now.
Translight Solar. Translight Solar.
Why? What's wrong?
Paper jam.
Introducing Ghana's leading pay-as-you-copy photocopier leasing company. Lease an A4, A3, heavy-duty or production machine and pay for only the copies made or design your own payment plan. Simple and tietia, that's not all. Incredibly, toners, repairs, maintenance, follow-me printing, centralized tracking all come free of charge. Remember, financial prudence is the name of the game. Folks, forget about the expensive gimmicks and be smart. Join the hundreds of satisfied clients across all the 16 regions and every sector of the economy and save over 60% of your printing costs. Visit us at www.valexlease.com or call 0244-644048. Be prudent and lease a copier. Terms and conditions apply. Valex Lease is a wholly owned Ghanaian company. Valex Lease, affordable document management solutions.
Mommy, good morning.
Good morning, my son. How are you?
I'm fine, thank you, Mom. How about you?
I'm fine.
Joe, I just saw your mom doing her usual morning routine. Like, it was just 2 weeks she underwent a major colon surgery.
Bro, see, my mom is doing perfectly fine, and we're all excited about it. It was minimally invasive surgery, and the recovery has been very fast.
Minimally? Hey! No, wait. What do you mean by that?
So they offered my mom a laparoscopic colon surgery. Laparoscopic colon surgery, which we accepted. It turned out it was equally safe with a very fast recovery time, and the cost involved too was very, very reasonable. She was discharged 3 days after the surgery, and you can see her, she's on her feet again.
3 days?
Just 3 days, bro.
Mean Tuber Hospital, First Ghana Colorectal Center, aim to serve a peculiar health need.
Another week is here on the greatest of all time show. My name is Giovanni Clip, and tonight we're bringing you talent. Contestant number 1, let's bring Baby Girl. Let's bring. You did it for you.
Cut. Oh, there is a leakage.
Where's the plumber?
for quality and durability, insist on Syntex pipes.
If you want quality, this be where you belong.
Strong, tough, and reliable. Your perfect match to your trusted Syntex pipe. Syntex pipe, it dey carry water, no wahala. Syntex pipe, it dey make water dey flow. Syntex, and you're strong, and you're tough.
Upgrade your print game with Konica Minolta, proudly powered by SkySat Technologies. From all-in-one machines that print, scan, and copy to professional systems and heavy-duty production machines, we deliver unmatched performance. Right now, SkySat has an unbeatable offer. 1 entire year of free servicing on all Konica Minolta machines. That's 12 months of expert maintenance for new and existing customers. Visit our new VIP Print Center at Pegasus Place, Airport Residential Area for a live demonstration. Call us on 050-164-5180 or 0302-798-829. Again, it's 050-164-5180 or 0302-798-829. SkySat Technologies. Performance that delivers every time.
Late night study session, endless assignments, and now these urchins and mosquitoes.
You guys are sitting here just have you done the assignment Mr. Pachi gave us?
How do we do those assignments?
These mosquitoes. Upload this and deal with these mosquitoes.
See miracle.
Abro mosquito spray. Solution to keep your home mosquito free.
Mom, this is what I call a good night's sleep.
Oh yes, baby. With Abra Mosquito Spray, you get to sleep comfortably and wake up refreshed.
Marketed and distributed by Kosharish Ghana Limited, number 5 Sprintex Road, Accra, Ghana. Please call 0243-690-066. Abra Mosquito Spray. One blast, total protection.
So this strategy will lead.
Oh no, not again.
Say, relax. The generator will come on now.
The generator is not working.
Why stress yourself when the experts are just one tap away? Introducing Left Power, the smart emergency support app from Left Signature Limited. With Left Power, certified engineers respond fast, anytime, anywhere. No delays, no stories.
Hello, sir. This is Left Signature Limited. The request has been received and our engineers are already on their way. Please relax. We've got you covered.
This is professional. Every Left expert is certified, verified, and can be tracked in real time. Oh, you'll know they're coming before they even arrive. From electrical engineering and solar power systems to data center management, cloud services, smart automation, and software development, Left Signature delivers excellence, fast, reliable, and professional. Left Power.
Your solution is just one tap away.
Available on Play Store and App Store.
Welcome to a place where everyday living is reimagined, where space, movement, and community come together effortlessly. With thoughtfully designed spaces, modern facilities, and everything you need within reach, you don't just live here, you feel safe, comfortable, and at ease. Step inside Eden Heights and discover spaces crafted for comfort, style, and everyday living. And just when it feels right, you will know. Because this isn't just about finding a house, it's about stepping into a better way of living. Eden Heights, the height of modern living. Book a private viewing today.
the Attorney General's Department has done its best. It filed the application. There are some additional documents that were asked for that it is filing, and eventually it will all go before an American judge to make a decision. But I do believe that even by virtue of holding a position like that for many years, I mean almost till the end of the regime, you held the most sensitive position as finance minister. And at a point when your own members of parliament, 80 of them, signed an application that the president should remove you, you said something historic. You said you are like the father of children and that you can't run away and leave your children. And so if we Ghanaians are your children, we're calling you, we're begging you, Father, come back. Your children are calling you to come back, you know, but just the act of fleeing, I mean, if you're a man of principle and you believe you've done nothing wrong, I don't see why you should flee your own country. And so we'll see what the legal regime is and how it proceeds. But whatever it is, if he's brought back, he will have justice. We believe in the judicial system of our country. You have the best of lawyers to defend him.
Right. So the president giving advice to Mr. Ofori-Atta. Some of your messages. Musa Abattoir says, Atacha is a good lawyer, but Wontumi's case is indefensible. Applying legal gymnastics will only weaken his argument. Anyone defending Wontumi's incarceration should focus on the court's findings rather than politics. The judgment serves as a warning to others. Canis Elijah says, with the discourse on the issue, much needs to be said about the defendant's representation at the trial. Atacha took over because unexamined implicating evidence. Something missing in your statement. Atacha came in the last minute and, like I say, to rescue, but it looks like belated. Now he's pursuing the appeal. And there are lawyers who will tell you that there are good grounds for appeal, particularly the anchor of the appeal will be the first ground that he raised, the constitutional matter. Nana Tay says, Wontumi provides security to protect land reclamation. He again provides no funds for the said reclamation, even went ahead to procure equipment for Henry Okun. He agreed, he gave the right to Henry Okun. He agreed, he permitted him onto it. Illegally. Where is the politics here? Atacha should know better. K. Amofa says, Honorable Atacha should know that Wontumi and Akonta Mining are not first-time offenders regarding illegal mining cases. The AG should have added the previous illegal mining cases to the charges. Now remember that there's one more case that he's facing about illegal mining, and then there is the Exim Bank matter that he's also facing, which he sought a plea bargain, which the Attorney General has now rejected, that didn't make a good offer or something of the sort. So if he doesn't get bail, he'll be attending courts from prison on that. Some of the prisoners really like that opportunity, even though it's not good. It gives them the opportunity to get some fresh air once in a while. This one says, we need to also ask what happened to the gold mine. Was it accounted for to the state? Well, the Attorney General did a plea deal with Henry Okun and Michael Jedu Aisi, those two people who were working, for Wontumi. So we don't know what went into we are told that they forfeited some things that they had. And remember that all the things that were also seized during the police raid on the place, including the gold and the money, have all been forfeited to the state. How did all this continue to be perpetrated without the regulatory intervention of the Minerals Commission? Who slept on the job and which officers are being held accountable. That is Senor Hosi sharing that with us. Thank you very much. And Senor says, we need to make one basic clarification. The principal earth-moving equipment used for reclamation is bulldozer, not excavator. By contrast, the principal equipment used for illegal mining, galamsey, is the excavator. This is common knowledge to the general public and certainly to anyone with a mining background, including Mr. Wontumi, who is a mining major. So the question becomes unavoidable. What was the real purpose behind facilitating the acquisition of 29 excavators for reclamation? If the equipment associated with galamsey is what was procured, and the equipment associated with reclamation is what was not procured, the inference is obvious. When it walks like a duck, talks like a duck, looks like a duck, and has the features of a duck, it certainly is a duck. Senor Hosi, thank you very much for that message. Kwame Che Ado in this area says that Regulation 276, that's the mining regulations, submission of plans before closure of a mine. The holder of a mining lease shall ensure that before the mine or any part of the mine is closed, abandoned, or otherwise rendered inaccessible, A, the plans required by Regulation 67 are updated, and B, copies of the plans are then certified as corrected by the holder of the mining lease and forwarded to the Chief Inspector of Mines, Minerals and Mining, Health, Safety and Technical Regulations, LI 2182. Wontumi ought to have done this if he was indeed reclaiming the land. And then shows further Regulation 23, notification of activities and appointment of managers. So there were a lot of things that if he wanted to do reclamation, he should have done. That's what the experts are sharing these messages on. Then, Wisdom says that I think Senior Atacha is not averting his mind to the fact that mens rea itself can be inferred. When counsel says 20 years would not deter others, he's then saying we need stiffer punishment to Anna. Kingsley says that documentary evidence is the highest form of evidence, followed by oral testimonies. Where documentary evidence is required to indicate a criminal charge, any form or oral evidence, no matter what, will fall short and will not fully discharge that burden without leaving a doubt. So the court will find it difficult to come to the conclusion that there was an assignment. Nothing that so maybe you haven't read the judgment, or you sent the message ahead of the portions of the judgment that we shared. Albert says that the law is in the court, not in the media. Atacha failed to challenge key evidence. Atacha was not a lawyer in there. Lawyers must focus on their case and stop arguing their case in the media. The judge did a thorough job, and judges can always have the benefit of hindsight after trial. They can sit back and look at the flaws in their case. So let's stop this. In the Dubois case too, same thing is happening. Arguing the law in the news. Somebody actually sends a message which appears a bit unfair, that the lawyers were, paying attention to the media rather than doing the work in the courtroom during the trial. Because listening to what the judge said, the lawyer failed the client. I read those portions out and people are saying, I'm the one saying, I haven't said anything. I just read what the judge said. You heard the judge said the lawyer did nothing. Wontumi cannot distinguish between any systems of democracy. He knows nothing about political systems. How on earth does such a person qualify as a political prisoner? What exactly was his political threat to the NDC for him to be jailed? Was he not the chairman of MPP in the Ashanti region when the party lost miserably in 2024. So by what measure does he qualify as a political prisoner? Does one need excavators to do land reclamation, post-surface mining, when all you want to do is plant coconut trees? Lot of questions coming in. Thank you very much. Forgive me if I haven't read yours. We will find time to return to some of your questions. But please, let me just read this two others. Andrew says that if the contention is that the guys were using Wontumi's equipment on Wontumi's legal concession, how can that amount to illegal mining? Okay, so that's not where the judge ended. So we need to read it properly, and I keep advising all of us, let's take our time and read it properly. The judge didn't just end there and say that that was what it is. Edubuahin says that a political prisoner is a person who is in prison mainly because of their political beliefs, opinions, activities of association, rather than for committing a genuine criminal offense. For example, a journalist jailed for criticizing the government. Am I one of those? An opposition leader arrested to stop them from campaigning. A peaceful protester imprisoned for demanding political reforms. In some cases, governments may accuse political prisoners of crimes, while human rights organizations argue that the charges are politically motivated. A simple definition is a political prisoner is someone who is in prison because of their political views, activities, or beliefs, rather than for committing ordinary crimes. So let's stop this. MPP, wise up, stop this. Okay, thank you very much. We'll be very brief on this, and my next set of guests are coming in. So let's see in the next 10 minutes, my guests have maybe 5 minutes each. What can they say as far as Ken Ofori-Atta's situation is concerned? So his son put in an application for him in the US for his status to be adjusted. Remember that he had overstayed his welcome and got picked up over that. So his son put up his application for him for the status to be adjusted so that he doesn't become a person who is living in the US, unlawfully. And the court sat on that, the immigration court sat on that, heard that case, and then there was some information that was given to the judge about the fact that he's being sought after to be extradited for crimes. And the judge made pronouncements on the OSP's affidavit, suggesting that there are no genuine crimes, charges against him in Ghana. If you look at the KPMG reports and all of that, he's not specifically mentioned as somebody who has committed a crime. And the Ghanaian media has published that widely in the course of the week. And some have criticized the judge for acting that manner. Yes, Mr. Seni.
Yes, so the judge did not have the benefit of the criminal case before him. He was sitting as an immigration judge, and that came about because the permission granted Ken Ofori-Atta, former Minister of Finance, to be in the United States had expired. So he was an illegal immigrant at that point, and so he needed to take steps to adjust his status to be able to continue to live in the United States. So for a judge to look at affidavit evidence, which was sent to him by reason of the fact that the lawyers of Ken Ofori-Atta wanted to make a case for the adjustment of status, and so brought in the affidavit evidence of the OSP, and for the judge to make a conclusive pronouncement on the criminal matter pending before the Ghanaian courts is totally, if you want, out of jurisdiction. The judge clearly, and America clearly has no jurisdiction over the criminal trial that is happening in Ghana. Just like America knows that criminal jurisdiction is territorial. And so, and unless by convention or by treaty, you decide that when a matter, like the ICC, by treaty, we say that certain crimes we can extradite to ICC for them to assume jurisdiction, crimes against humanity. Apart from that, and America itself does not even buy to that, does not subscribe to that view that you can outsource criminal prosecution. And so that's why they are not members of the ICC. And so for a judge who is just simply sitting down looking at whether or not to adjust.
But Council, I'm informed that as part of the affidavit evidence was what OSP had, put out. So,
but you know, as a matter of fact, that affidavit evidence cannot be used in the criminal.
So it's not an adjudication properly so called.
That's why he ought to have restrained himself from making conclusive pronouncements on the criminality or culpability of Kenneth Uriata. And you could have gone ahead and said, well, I'm adjusting your status by ill health on humanitarian grounds.
His status had already been adjusted at the first instance.
Yes.
And now adjusted again for him.
Yes, so you don't. And that's why people are reading a lot of meanings into what the judge did. Because we now hear that they were classmates at Yale University. And
really?
Yeah, classmates.
They actually say that he stole the...
he came for attending Yale. That also, and that one of the reasons why he thought he could adjust his status is just because he attended Yale and he was a good man. He also said something that is escaping the minds of Ghanaians. He said the man is, very resourceful. He's rich. He said that in the judgment. And so, and many other things. And for me, you see, this case is...
Uriata has always been rich. Before he became Minister of Finance.
You don't know of being rich. He has always been a businessman. That one
commanding a very big, going concern. That's equal to being rich.
That doesn't make him rich. That doesn't make him rich. That doesn't make him rich at all. But let me say things on this platform. You know the amount of money he made when he became Finance Minister. You know the amount of money. So please. Now,
Council, why do you want to make something?
I'm not making anything. I'm just saying that. I'm not saying that. Let's leave it aside and see whether what he said.
He was driving in his own car. He was not even taking salary at a point we were told. So what are you talking about? If he made money by his salary for the number of years, what is that? Or allowances? What are you talking about?
What are you talking about? That not taking salary makes you a rich man. And you know the number of people who in this country have occupied political offices and have not taken salary.
You do a lot of political imagination.
Yes, he established insurance companies, he established a bank. We know that. But that doesn't make him a rich man. That makes him a resourceful person. And he was looking for more resources when he went into a public service.
He's never paraded his wealth. That's what I know. He's never paraded. He's a very simple...
He was resourceful enough to, as we heard, bankroll a presidential candidate. In this country, we're told that you need not less than $100 million to run a successful presidential campaign.
Yes, but you also...
So he was resourceful.
Just recently, me and you attended a conference. You also know that when he bankrolled that party, that gave him the permission, the opportunity to become a finance minister.
But there's no support for this assertion that he bankrolled.
He said it. He said that when MPP took how much, $1 million or $10 million loan from a bank they couldn't pay, he paid. He said it. We didn't say it.
100 million. We took a loan, 100 million from a bank.
Oh, forgotten.
I don't know. It was actually in the public there. Really? There were letters that were running out in the public.
He said he paid for it.
Anyway, that's not the subject matter. The subject is that he got his status adjusted. The judge made comments about the prosecution.
And again, let's be clear on this. What Ghana is pursuing is not his immigration status. What Ghana is pursuing is his extradition. And the adjustment of status does not in any way compromise the application for us.
Really?
Yes. No, it doesn't.
Doesn't it enhance his chances of not being extradited?
No. I mean, Abu Trika is a Ghanaian. He's not a Ghanaian.
You see, the whole thing is...
so extradition...
You see, extradition...
Let's hear Atacha.
Counsel, and you agree with me, I'm sandwiched between two prominent lawyers. And you want me to discuss my grandson, but I'll try. Let me tell you something. Extradition is a very serious legal process. You should persuade the judge that, look, this person has done some crime or committed a crime or whatever it is in another jurisdiction and should be brought to face the law. And you also have, with all respect, opportunities to even appeal against the decision of the court of first instance and to wherever you want to go. So it's not a very simple process. And I think we should look at it from that perspective. But I didn't like the fact that the president said he shouldn't run away from justice and he has fled the country. But he went through.
But that's true.
No, but he went through Kotoka International Airport.
But he fled.
No, he did flee.
So he fled.
He actually wrote sought permission from both the chief of staff then and the new chief of staff. They granted him permission to go.
The incoming chief of staff. But what happened?
And when you copy, what is the purpose?
So Samson, what happened?
So he didn't flee.
He indicated the day he will return.
28th of February or so.
And there were health challenges.
And so the first time,
with the greatest of respect, there is conclusive evidence that he had to leave the realm because of serious health challenges, and we don't want to air it. So when a man is fighting for his health, I don't want it to be misconstrued as fleeing the realm because of a possible prosecution.
Okay.
Yes.
And
he fled.
But from where you sit,
he fled the realm.
This will impinge on the extradition. In the US, as we know, it's not like the way we do it here. They come, they ask for you tomorrow, you are on a plane. Over there, it takes between 3 to even more years before extradition is successful.
Yes.
You think that this one will affect our chances of quickly bringing him back to Ghana, right?
No,
the question is to attach us.
Okay. I think so. It's not going to be easy, but there's a critical matter that we should all look at. Let's give him the space
to do what?
To think through his returning. That's my humble view. You see, let's give him the space that he should come on his own accord. I don't believe it will sit well, with our sense of life, that he's hauled here based on extradition order. So, but these are matters.
Opportunity was granted.
These are matters that I humbly want to say, with all respect, that he understands all the nuances of extradition and the rest of it, where a court orders that they should haul you back to the country where they want you to face justice. So therefore, I am of the view that we should give him the space to elect to come voluntarily. And we will see how it pans out. But
he was given that space.
Okay. Professor Piejetua, what do you say about this? And I've been reading an article written by K. Kujo, the prolific writer. And he writes and he speaks about the fact that, at the time Kenufureta was going, OSP had not charged him, had not become a subject for which OSP could hold him.
Yeah.
But the Jubilee House knew about it, immigration people knew about it, all the security installations, everybody knew about it, and nobody did not anything. Nobody is blamed. It is the OSP that is taking all the blame. What do you say?
The OSP is being overly held responsible for the so-called fleeing of Mr. Furiata. I think that there are other agencies involved who could have been held responsible, or who should be held responsible as well. We're talking about the Attorney General's office, talking about the security agencies and so on. But the point also is that he didn't really flee because he got permission to go and seek.
But he overstayed his permission.
Okay. Well, he overstayed his permission or the time frame given him. But we also know that he showed evidence that he had to undergo further healthcare, even including a surgery and so on. So that means that he needed extra time to be able to be in that country. As of now, I don't know what else is keeping him there. But the bottom line is that now he has applied for immigration status. He's now got his green card. And my comment here is on the action taken by the judge. I agree with the positions expressed that he went beyond the boundaries of what an immigration judge is supposed to do. And that the matter before him was simply to look at the case on humanitarian grounds, because he has overstayed his time, not only from not returning to Ghana, but also his stay in the US. And for that matter, on humanitarian grounds, the judge has a discretion to decide one way or the other. But bringing in the OSP's application and so on, I think muddied the waters, and it sort of brought in that kind of bias, which has led people probing into his relationship with Foriata and so on. So if in an immigration case, you can look at the criminal side of a person in the application, but this is solely in respect to the crime that he has already committed, but not crimes that he is alleged to have committed. So that issue shouldn't have come in at all. But the question then as to whether that can impact on the extradition process, I think it tells you in the first place that the two issues are completely different: the immigration process and the extradition process.
Precisely.
And the extradition process, as we know it, involves a whole set of processes that begins or has begun in Ghana and goes back to the country where the extradition is being sought. And I think that is where we already know how the Attorney General and the OSP...
In Ghana, they come with their officers, and then in 1 week or less, they carry our people away. What do you mean by it takes a whole process?
Well, that's the point I was coming to, that yes, Ghana seems to compromise or seems to have compromised on a number of occasions with when it comes to extradition of somebody from Ghana to the US. And so that is where the government and even the president himself making that statement made me wonder what diplomatic processes went behind the scenes to ensure that Foriata is brought back to Ghana. Okay. We could have used Abu Trika and other cases where Ghanaians have been bundled and taken to the US as a leverage to argue that you give this to me, I give that to you. That is something that happens in diplomacy all the time. But Ghanaians seem to have been in a hurry to rather violate the human rights of the person being sought in Ghana, to bundle him or her and take the person to the US. But when it comes to our case, we have to follow the strict process of the law. In any case, I am of a view that, and I think it's supported by case law, that the application for residential status does not in any way compromise the case that is the extradition matter. Even citizens of the US can be extradited to Ghana. There have been cases like that. So it doesn't in any way compromise that at all. What is compromising the case rather is the tough battle that is going on between the AG and the OSP, which may play to the advantage of Mr. Ken Ofori-Atta.
Interesting. So there's a possibility that this can play to the advantage of Ken Ofori-Atta, right?
Yes.
Yes.
Okay.
Yes.
Okay. Thank you very much. And I'll direct you to read the K. Kudjo's article that I was just referring to, and it's an eye-opener. It's an eye-opener. He says, among other things, I'm reading that to close my subject on this. He says that this was not an ordinary traveler catching a flight overseas. This was Ghana's immediate past finance minister. His ministry had become the center of major public controversies. The SML transaction was already under investigation. The KPMG audit had been commissioned. Oral had been announced. The country was in the middle of a presidential transition. This was no routine January holiday. And he says, according to available information, Ken Ofori-Atta wrote to both the outgoing and incoming administrations explaining why he was traveling. And as far as he's concerned, that he was going to return on the 28th of January, 2025. Neither side objected. National Security reportedly cleared the trip. The OSP was not part of the approval process. All other places watch for him to go. And now we are all complaining. We'll be right back.
From the heart of Africa we stand, building dreams roots across the land. Every step we did your side, helping you rise, taking you higher. Strong as a group, close as a partner. Bank of Africa lifting you higher. African Bank with global reach. BOA make your future glow. Strong as a group, close as a partner. Bank of Africa lifting you higher. African Bank with global reach. BOA make your future glow. BOA, we go there for you night and day. Strong as a group, close as a partner. Bank of Africa lifting you higher.
Bank of Africa, as strong as a group, as close as a partner.
Day by Day exists in lotion, cream, soap, and more. Day by Day has 4 fragrance range.
To complement brushing, use a mouthwash daily to reduce harmful bacteria that cause bad breath, tooth decay, and plaque, which can lead to bleeding gums.
Rinse Fresh Go. For the maintenance of oral hygiene and healthy gums, you need Nesta Antiseptic Mouthwash with chlorhexidine digluconate, effective for the treatment and prevention of bleeding or irritated gums, mouth ulcers, plaque, and bad breath. Rinse Fresh Go. Get the confidence and protection of long-lasting fresh breath with Nesta Antiseptic Mouthwash. Rinse Fresh Go. Available in original and fresh mint flavors. Manufactured and distributed by NS Chemist Limited. This advert is FDA approved.
Late night study session, endless assignments, and now these urchins and mosquitoes.
You guys are sitting here just have you done the assignment Mr. Pachi gave us?
How do we do those assignments? These mosquitoes.
Let me quickly upload this and deal with these mosquitoes.
See miracle.
Abro mosquito spray. Solution to keep your home mosquito free. Mom, this is what I call a good night's sleep.
Oh yes, baby. With Abra Mosquito Spray, you get to sleep comfortably and wake up refreshed.
Marketed and distributed by Kosharish Ghana Limited, number 5 Sprintex Road, Accra, Ghana. Please call 0243-690-066. Abra Mosquito Spray. One blast, total protection.
Malaria's remedy is Lonat. Therefore, we're gonna use Lonat to recover. You have malaria? Yes, please. Are you shivering?
Yes, yes.
You got chills?
Yes,
Take Lonat.
Lonat.
First day.
Lonat.
Take Lonat. Second day.
Lonat.
Take Lonat.
Lonat.
Third day.
Lonat.
Take Lonat.
Lonat.
That's all. Lonat scatter malaria. Lonat scatter malaria.
This advert is FDA approved.
clarify something. My deputy minister's pronouncement relates to releases.
Yes.
Releases are different from payments.
Okay.
For example, you may have goods and services release of say 300 million. At the Ministry of Finance, I will have to release it to a sector ministry. The sector ministry will have to go through the process of accessing the money through the GIFMES platform. It involves the loading of invoices and others and availability of cash before it tends to become payment.
Right, so the finance minister was in Parliament and brought the midday review. He's not asking for extra money, but it's a genuine growth we have been talking about. My first set of guests have left us. Samuel Atachia, Lead Defense Counsel for Bernard Entry-Boesiako, aka Chairman Wontumi, Inus Afuseni, a former MP Tamale Central and former Minister for Lands and Natural Resources, and Professor Kwejo Appiagyei Etua, Professor of International Law and Human Rights at the School of Law. He does his inaugural lecture, and I think the last week in August at the University of Ghana. We should go and see that. My guests who are joining us now to deal with the economic matters and the numbers. Yao Appiah-Lartey, right? Yes, I was just talking about Professor Appiagyei Etua inaugural lecture that he's going to deliver on August 27, 2026 at the Great Hall of the University of Ghana, the premier university, at 5 p.m. So you're all invited. You can be sure that he will give you something to think about. Students struggle for academic freedom and Africa's democratic renewal. Right. So my guest now to deal with the financial matters and economy, Yao Appiah-Lartey, lawyer and partner, strategy and transactions and Africa infrastructure and capital projects lead at Deloitte Africa. Fred, before I go to Fred, is Dr. Gideon Boako, MP for Tano North and member of the Finance Committee of Parliament. Fred Kwashi Aute is lawyer, Vice President, Chartered Institute of Taxation, Ghana. Where envy these people, they have how many professions all put together, and all of them are difficult professions to deal with. Welcome, good morning to all of you.
Thank you very much.
Thank you very much.
Right. So, yes, Atufosing has been crunching the numbers and telling us a few things. Let's hear him again briefly as he speaks on the floor of Parliament, and then we'll return to you. Our bigger question is, are we dealing with a genuine recovery or not?
We will never conceal our challenges or exaggerate our successes. Trust is about the truth, and truth must remain the foundation of sound economic management. Our responsibility now is not merely to celebrate these gains, but to preserve them for future generations. Economic stability is not an event. It is a duty renewed every day through prudent stewardship, fiscal discipline, and unwavering accountability. Almost 4 out of every 5 cedis of the potential excise tax based on wine and spirit escaped the tax net. Mr. Speaker, only 1 cedi out of every 5 cedi was subjected to excise duty. That is neither efficient nor sustainable, and this must change. The excise duty bill before this House introduced a comprehensive package of reforms to close these leakages. Mr. Speaker, we will crack down this leakage. Ghana has regained the ability to mobilize long-term financing in its own currency for development. Right Honorable Speaker, I'm proud to announce that Ghana has now overcome the original sin. Mr. Speaker, we have overcome the original sin. Whilst I now take you to the sinking fund. While Ghana's debt restructuring is nearing completion, prudent debt management requires us to look beyond today to tomorrow's obligation. Mr. Speaker, in 2027, DDEP bonds that will fall due is 58 billion Ghana cedis. Another 53 billion Ghana cedis will fall due in 2028. In 2 years alone, Ghana has to repay 111 billion cedis.
I can confirm to you that there was not even a single request for payment from the Ministry of Finance to the Ministry of Finance, of which we have not.
From the project implementers?
From the project implementers. Work done. No, nothing.
They are not asked you?
No.
Although we know the flag was coming?
Nothing. There was no request for payment. In authority. I mean, I'm saying this on authority. No single request for payment before ministry.
To release the Gary fund?
To release the fund, no.
So because after the time the flood happened,
there was nothing before us. Nothing before us. And so I think a lot has gone wrong in the past.
But if you may forgive me, this is a project that is under the Works and Housing Ministry.
Correct.
And the Works and Housing Minister is your colleague in cabinet.
Oh yes. I mean, it is not him. It is you have a project implementation team. We inherited it. We inherited the project.
Okay, so the last bit was about Garrett, the funds and how it was used, and we have heard other economists suggest that this is not accurate to suggest that the monies were put into uses that were not useful because of purchase of vehicles and training and all of that, because that is normal with all of these funds that come in. But let's focus on the bigger question of the budget. What I'm going to do is first take your preliminary comment on the broader budget as presented in 2 minutes, and then we'll return to begin for you to have your discussion. So let's begin with you. Yes, yeah.
So thank you very much. I think listening to the finance minister, I was in this studio actually, and I listened all the way through. Before he read the budget, we had some discussions, and the first one that we looked at was to look at the first quarter performance of the year.
Okay.
One of the key observations you notice from the budget reading and on reported by state agents like the Ghana Statistical Service is that our revenue from indirect taxes, levies, VAT had gone down. But on the other hand, revenue from corporate income tax and PAYE has gone up. What it meant was that when government took power, they abolished some of the taxes and they call them nuisance taxes. One of the arguments that we've had as business advisors over the years is that some of the taxes were crippling businesses. And so if you remove those taxes, you increase productivity, and in return, you have the benefit on the other side. So yes, indirect taxes revenue has gone up, but corporate income tax went up. PAYE, that's employment tax, also went up. So if you remove some taxes, you give the opportunity for productivity to increase. When productivity increases, you have the benefit on the other side. And I think it's instructive that there's some aggressive business tax reforms. One of them is the removal of 20% excise duty on manufacturing of fruit juices in Ghana. So why would a Ghanaian manufacturing fruit juice in Ghana have an excise duty of 20% when someone can import the fruit juice from wherever and compete with the same Ghanaian manufacturing business in Ghana? So I think those aggressive tax reforms have some good benefit for us. On the flip side, we should prepare for the headwinds that are coming. The Strait of Hormuz has reignited. We are likely to have its effect in increase in oil prices, affecting our exchange rates and affecting our tax revenues. And I think our preparedness for some of these headwinds is something that will be instructive going forward. I think maybe we can discuss that as we get along.
Right. Fred.
Okay, thank you very much. Looking at the budget, I think the tone of the budget is particularly, you can see it from paragraphs 363 of the budget, for which the minister indicated that they want to pursue a fiscal discipline. And typical of accountant is to ensure that there's prudence. And I'm not surprised that the minister is a chartered accountant, and for that matter, his objective is to ensure that there's certain level of stability within the economy. And I would say that if you look at, I'll go back to, history. If you look at Kojo Bawum's time, you see that he's also an accountant. His pursuit is on the issue of stability. You come down to say Tekpe, who is also a typical accountant, the same thing. So it is not surprising that the minister is pursuing the agenda of fiscal discipline rather than trying to look at how do we spend. That is one thing we have to be much concerned about. But just like my colleague just said, there is something which is very concerning. That is the revenue aspect, which I think we are doing very bad in that respect, which is so much concerning in this case. Despite the fact that the minister's objective is that if I don't have the cash, I cannot spend. So you can clearly see it from the budget. Now, the question is, with this budget, have we recovered from the downturn that we had? The minister said we are out of the emergency room, but I don't think we are still at the borderline, looking at the way the numbers are flowing and the statistics is going. So it means there is more work to be done. And I believe as we go on to discuss where the work has to be done, we will discuss that as we go along. Thank you.
Right. Gideon.
Yes, I think it was a good presentation. If you have followed finance ministers from, I think, Osaf Mafo's time to Atufosin, it appears they don't joke with the opportunity that the Constitution or the President grants them to have 2 opportunities in a year to talk to Ghanaians, where everybody is listening to them. And so their presentations in Parliament have been greeted by, some kind of euphoria and attempt to also tell good stories about their leadership and stewardship. And so this one was not different. I, however, observe 1 or 2 gestures or attempts by the minister that I think he shouldn't have, allow himself to be carried away into that. First was the ambitious claims that he sought to make, some of which were not factual. It's important that we look at some of these things because the credibility of the presentation is as important as the presentation itself. First was the claim that this budget presentation is the first time that the media review had not asked for additional funding.
It is not?
That is not true. In Kenneth Ratter's 2023 media review presentation, if you look at page 3, specifically paragraph 18 to 21, he stated categorically, and in paragraph 21, he said, Mr. Speaker, we would therefore not require a supplementary budget. So this is not the first time it has happened. The other thing is that the minister said this is the first time.
How could he have missed that? Well, say that this is the first time.
Well, this is not the first time Mr. Atufosin is saying that. Remember in the 2025 budget?
Just 2023.
Yeah.
This was done.
In the 2025 budget, he also said that was the first time Ghana had recorded, I think it was the review, declined rate of debt accumulation, but that was not true. Asaf Mafo observed that, and even latter part of 2024, we saw that. So, that was not right to say. Then also he said that this is the first time, again, that Ghana has recorded GDP nominal terms over $100 billion, and that is also not true. In 2024, I remember we hit 1.2 trillion cedis. In present value terms, that is more than $100 billion. So that assertion was not right.
Okay, so you pause there. You have done more than 2 minutes.
Yeah.
The other guys did less than 2 minutes each. But I know you guys, the politicians, it's difficult to keep you to make a preliminary comment under 2 minutes. So if you're just joining us, we are now zooming on to the questions of the budget review, media review as presented by Kessel Atufosin, the finance minister, and asking the most, central question on the back of the claims of the minority that the growth or the recovery that we appear to see and the finance minister talks about, they seem to suggest that it's not exactly genuine and there are certain issues with it. But we have our experts here to assist us to answer that. And the usual fire in Parliament, there are some people who are not excited about, particularly the minority leader's comment after that, appears to have abandoned the budget and talking about release of political prisoners and all of that. And I took note that on a very light note, Kwame Boafo Akufo of Ekropong Ekwapem, that great lawyer who has the gift of the gab and who is teaching our Gen Zs that you can be whatever professional and still be deeply traditional, and preserve our culture. I think you guys owe him something, because I was hearing people use in Parliament, the phrase community of reading men. He was the first to have used it for the first time here on Newsfile when he was provoked by Martin Pebu. I think Dafia Makpo, Kojo, all of them are using it. That sounds like intellectual corruption. You should credit him. Yes.
That is true. I think
he used it the first time here.
Yesterday I read a letter he wrote on behalf of Adjoa Safwa.
Okay.
He used lamented. He was referred to the late Apostle Kojo Safwa.
Yeah.
He was the lamented, kind of.
That guy has a gift of the gab. And so MPs, we beg you, no intellectual corruption. Kwame Boafo Akufo of Ekropong Ekwapem is the guy who used that expression for the very first time. When you are doing it, credit him. So, Gideon, I'm beginning with you.
Yeah.
Yes. What's your take on the budget?
So, broadly, if you look at the presentation, the content, before the presentation, we were all privy to the figures and the numbers. There's no doubt that there is some economic improvement. If you want to look at it on the surface of indicators, GDP growth, inflation, and all of that, there's no doubt at all that you see significant improvement. But what is important is that this whole concept or discussion about macroeconomic stability is like having a thick forest with a thick canopy in a rainy season that has leaves that looks quite blossoming from afar. But once you get closer to it, underneath, you will see the true picture, whether or not the trees are together or they're isolated, and whether the underneath is dried. So it's important to dig deeper into some of these economic indicators. What I did not like about the minister's presentation of these economic achievement is what I would term as the attribution bias that he's presenting.
Before you go to the substantive, as you are beginning to do, you sought to make some corrections.
Yeah.
That he said this was the first time that we're not asking for supplementary, what is it?
Supplementary budget.
Great. But was it an extemporal comment or it was in the statement itself? Can we find it there?
It was in the statement.
So can we find it?
Yeah, I think we can find it.
We can find it?
I have to cross-check the exact.
We'll look for it.
It was in the statement.
We'll look for it because it does look like that may not be exactly what he said. But you go on with the substance.
So there was an ambitious claim by the minister that the gains we have seen in the economic sector is solely due to a superior domestic management, without acknowledging the process that has taken place that led us to this point. And for me, that attribution bias, I think, was not right. It doesn't speak well of the minister because he needs to recognize the fact that we have come from somewhere, okay? And what he put out is not what is, in the letter and spirit of all the IMF publications that we have seen. The IMF itself highlights continued implementation of the IMF support program because whatever gains we are seeing today is on the back of the IMF program. The minister didn't want to acknowledge that the IMF program has contributed to this success. And then also the progress of the debt restructure is something the minister lost sight of the fiscal consolidation, the structural reforms, the favorable economic conditions, and including his own ongoing policies. So I won't take anything away from him, that this government has also executed some policies that have aided us to where we are, even if, upon assumption, they decided that they will not do anything. The decision not to do anything to what you inherited is itself a decision. And if it leads to good results, it must be commended. So it is important that we recognize that whatever has brought us here, it's multi-causal and not monocausal. It's important to realize that. Once you have that, and this is supported by, if you look at the National Development Planning Commission 2025 Annual Progress Report, page 4, and Mr. Nimoy Thompson writes, it says, following the debt exchange program and the third and fourth reviews under the IMF Extended Credit Facility Program, improvements were recorded in some selected areas, including fiscal consolidation measures, expenditure rationalization, monetary policy tightening, debt restructuring efforts, and reforms aimed at restoring confidence in the foreign exchange market and strengthening service accumulation. This provided a strong base for policy implementation in 2025. So there's clarity as to what has or have occasioned us to this point. So the minister ought to recognize that at the least. Now, something, if you look at the economic gains and where we have come to as a country, there's a critical question that we need to ask ourselves as to whether the gains we are seeing the improvement represents a durable transformation of the economy, or whether part of the fiscal success is being achieved through expenditure compression. We were talking about revenues, and if you look at the government revenues, the finance minister at his vetting I was there said that he was going to work to ensure that there's a revenue to GDP target of 18%. Last year, we did about 15.7% as reported by the finance ministry. Bank of Ghana reports 16% or so. The 15.5 is far below what they inherited. So revenue is underperforming. Now, when you have your revenue underperforming, as was indicated by my friend to my right, in Q3 2025, we began to see the revenue fall below 4.1% target. There were shortfalls in PAE, corporate tax, VAT, excise, growth, and sustainability. By full year, the revenue shortfall had been huge. Now, if you come to 2026, it's the same thing. There's a revenue shortfall. And I was particularly not happy that when the minister was reporting the revenue figures, he altered the figures partly because the revenue, total revenue and grants for 2026 was 268 billion. If you divide by 2, that gives you 134 billion for half year. And if you juxtapose that against the outturn of 124.7 billion, that gives you a shortfall of about 6.9 to 9%. The minister understated that in his presentation. But if you go to the appendices in the budget, the true picture is created there. That tells you that we have a serious problem as a country with our revenues falling. And that led to the expenditure undershooting. When you have lower revenue and your expenditure is low, you will attain primary balance surplus in the positive. But that means that it is going to affect the country and broadly what you have to deliver to people in terms of roads, power, water, irrigation, industrial parks, and all of that. We need to ask ourselves as a country whether or not we want to achieve economic figures, economic indicators that look good at the expense of what we have to deliver to the people of this country. Because mind you something, when your revenue revenue falls and government cuts expenditure, that is not prudence, okay? That is growth that is postponed. You can have prudent economic management, primary surplus, without necessarily having to cut expenditure. You have a revenue target to meet. It is based upon that you have set your primary targets. If you're not able to raise the revenue and you want to punish the ordinary people because you didn't raise revenue, and for that matter, schools should not be built, roads should not be built, that is not fair to the people of this country. Now, if you bring it down, for instance, if you go to my constituency, our farmers in communities like Santasi, Subri, Suya, Fudia, and Kwanta, They are into maize growing, cassava.
There's a Santasi in in Tana North.
Exactly.
Okay.
They grow tomatoes.
Santasi in
they grow tomatoes, they grow cassava, they grow maize. When the feeder rows are not delivered, because revenue targets are missed, those tomatoes rot before they reach market. That is not prudence. That is post-harvest loss. And every single post-harvest loss is a hidden cost to the farmer, because we lose between 30 to 50% of vegetables produced in this country because of poor feeder rows and no storage facilities. For tomatoes, 45% is lost annually. Last year, the estimated...
That's too much.
Yeah, last year, the estimated tomato production was 1.7 billion cedis in this country. If you lose 50% of that, okay, that is about 900 million cedis of income that is supposed to go to the farmer. That is lost. If you're unable to provide the feeder road that will facilitate the farmer to cut the produce to the market so that it is not lost due to post-harvest losses, you are punishing the farmer. Then again, our industries, the fitting shops, hair salons, the cold stores need reliable power and good roads to operate. How do they get that? When those infrastructures are deferred because government could not meet revenue target and consequently cut expenditure, the machines shut down, workers are sent home. That cannot be termed fiscal prudence. That is jobs that have been lost, that the Ghanaian youth should have benefited from. Then again, when you are unable to raise revenue that is needed, and we delay projects and arrests, contractors charge interest on the delayed payments.
Right.
Okay? And this imposes additional hidden costs. Deferring infrastructure is not free. It is the most expensive debt that we can leave for our children. So the finance minister ought to get that. Then we also need to juxtapose this whole economic stability against social stability.
All right.
It is not prudent to say that you want your economic indicators to look good when people are socially unstable. Now today, if you go to our streets, in our homes, there is social instability. Youth unemployment is high.
Which is not a new development though.
But is it increasing? It is. Youth unemployment is high. Cost of living still buys. Today, something in Accra, a piece of tomatoes sells at 10 Ghana cedis. Today in Accra, if you want to buy tomatoes, just one piece of tomatoes, it's selling at 10 Ghana cedis. You need to get 50 Ghana cedis to buy tomatoes before you can prepare a meal for your home. And so when youth unemployment is high and cost of living is biting, trust in institutions fall. If our economy is stable on paper, but our society is unstable on the ground, we cannot claim true national stability.
Okay.
A stable city, something means nothing to a nurse, a trained teacher, or any graduate who has been unemployed for 3 years. Low inflation means nothing to a graduate who has become a burden onto his parents and siblings because of unemployment. Economic stability does not translate into social stability. Okay, it is a ticking time bomb. And the finance minister says
that as an economist, you should not be saying this.
I'm saying this because
these indicators are important.
Nobody is understating the importance of these indicators, but we should not assume that they are the finality. Okay, we should not assume.
Has anybody done that?
Oh yeah. I mean that is what the finance minister is trying to indicate.
So you have had about 10 minutes in making your first your presentation. I would like you to hold on and let me go to Yao and Fred. Tell us about your outlook, and if there are issues he has raised that you want to look at, do that as well. But whilst you're doing that, I'll ask Gideon to look for the specific statement that the minister made that he accused him of, that this is the first time we have gone for the mid-year and are not asking for supplementary. Yes, Fred.
I can provide that now.
Look for it. When you find it, let us know. You found it already?
Yeah.
You have it? Okay, read it. What does it say?
So if you go to page 3.
Page 3.
Paragraph 12.
Paragraph 12.
It says, Mr. Speaker, today I am not here to seek a supplementary estimate. The 2026 appropriations remains unchanged. However, we are undertaking the strategic realignment of expenditures within the existing appropriations.
He didn't say this is the first time that, their finance minister.
He said that. That is not in test, but he said that.
He did?
He said that is the first time.
You know, the first question I asked you was whether that was example.
Yeah, he said that.
Or,
he
but
said
you said it was in text.
You know, the minister, when he does a presentation, sometimes he looks into parliament.
Okay.
Based on the reaction.
It's important. We'll have to fact check that.
But he said that,
We'll have to fact check that. Yes,
it was
Fred.
part of his speech.
Okay, thank you, Senior. Yes, when you look at the budget and the figures, the annual budget as was read in November, expected revenue was about 268 billion. You will have generally said, okay, divide that 1 by 2, you have about 134 billion. But you see, budget is not in that way. You estimate on monthly basis. Budget revenue accumulation may not be evenly. So on that basis, on monthly basis, how much do you think? Possibly you may have accumulated of fund in a later part of the year, and that when you put them together in terms of the total, you then get.
Do you agree with this statement, this description that the economy is stable on paper?
I do not really agree on that, because the reality is that inflation has dropped to about 5.3%.
Right.
That is a fact. Exchange rates have been a bit stable. That is also a fact.
But threatened by Hormuz.
But I mean,
threatened by the Strait of Hormuz.
That is it. But that is what the economic managers are there. Right. I mean, for in a case of emergency and kind of things, and that is a test of a leader or a finance minister. So we will not say that we do not have realized that in reality in our pocket, because the fact as it is showing that, I mean, when you go to the bank, you want to change your money, you will change it at 12 cedis or 10 cedis, depending on where you go. But another issue is that, as I've explained, which my other colleague from DLH stated, was on the revenue performance. And then the minister when they assumed power, they tried to, introduce certain tax law. They want to amend or reform the whole tax structure, which is good, particularly if you look at the value-added tax. The value-added tax was a bit distorted, and the way it is calculated, quite cascading. They've come to do that correction, which is good. But you will also notice that we are competing, when it comes to tax competition in this case, we're talking about you competing with other countries. Our VAT rate effectively is about 20% now, but compare that to our colleagues in Nigeria, which is 7.5%. That brings a lot of disparity. So if somebody wanted to come and do business in Ghana and want to compare to Nigeria, he will have gone to Nigeria all the same, because the cost of doing business there will be quite low. So if you look at our effective tax rate within the region, is quite still very high. And then, so I am not that surprised to see that VAT performance continue to be at the low side because of possibly of the rate. Then one other thing that we have not seen in the revised and in the media budget, which is concerning for me, is the issue of tax education. You see, tax education, though the Ghana Revenue Authority...
Did you say you expect to see that in the...
It must be. There must be. For example, if you look at the 2026...
I thought that was in the natural course of things.
No, there must be, a determined program to indicate how you want to let people to be aware of the tax system, the tax rate, how they should pay the tax.
And that must be costed?
That must be.
Okay.
At least if it will not be costed, it must show that this is the commitment you want to put up. The minister really did that in the annual budget in November, that we wanted to do quarterly tax education.
Which they have been doing.
But we want to see how they have performed that and what is the revenue generated out of that. It's not showing in the budget. That means that there is certain thing we have to do to improve on the tax education.
Not mentioning it suggests non-priority, may suggest non-priority, but not that it's abandoned, correct?
You'll be right in that angle. Then another thing which I think, me as a tax practitioner, is I want to see how do we align our tax infrastructure to the international tax practice. currently ongoing, we're talking about digital economy. When you look at the budget reading, somewhere from 2021, every year, you see that government intends to start digital economy. That is, those who do business online, Google and others, they come to do business here, but they don't pay income tax.
Not the same as e-levy, right?
No, not the same as e-levy. E-levy is a different thing.
You're running away from it all the time.
Yes.
It looks like it's inevitable, right?
Yes. So we do not see this, though this is the mid-year budget, is just coming to tell us the performance of government. But at least we want to know what government is doing on the taxation of income arising from online businesses that are carried out by non-resident person. You will not see that in the mid-year budget review.
We actually, there's a bill going to Parliament next week to kind of deal with this cross-border taxation.
I think that will be in respect of possibly on indirect tax. We're talking about income tax.
Okay.
Yes. So that's why we look at that. I'm talking about income arising, not transaction arising from that. They are two different things altogether. So digital taxation has been a loss. Although government has done something on the part of the value-added tax experts of the online transaction, and the minister has alluded to that a device or software has been procured to ensure that non-resident taxing of their transaction is done, and then they are bringing a bill to Parliament to put a statutory issues, or a statutory law on that aspect. I think that is what he's talking about. But that is clearly different from the digital economy taxing the income. For example, you and I, we pay payee. And if you have a business, you're going to pay in corporate income tax.
That's right.
But do you tax Google in that respect? No, we don't do that. What we are doing currently is a transaction aspect of it, which is the VAT. Like you go to the shop, you pay the VAT.
Okay. Okay. I want to come to you, but you finish up on the point.
Thank you very much. Now, much concerning for me is that you look at it. Yes, income tax is doing very well. There's an increase. But when it comes to the indirect taxes, clearly there's something which we have to, government have to try as much as possible to ensure that they improve. When you look at the statistics, you will notice that they have indicated that excise duty is not doing very well. And then also, customs is also not doing very well. And based on which government is putting a bill to amend the Customs Act and then also to amend the Excise Duty Act. And I believe if some of these laws are passed, we'll see maybe at the end of the year how the revenue performance in terms of the customs and then in terms of the excise duty will span out. All right. I think we'll come back.
So, when Gideon says, I'm not trying to pigeonhole you into his points, but he says something I suspect may not be fair to the facts. He's talking about how many percentage, 40 to 50% of tomato getting rotting because we are not committing to develop, build the roads that have to be done, and so on and so forth. We know, as the finance minister presented, a whopping 500 million World Bank facility to construct a 1,050 kilometer of agricultural roads, is it? 500 million World Bank facility to build and upgrade schools. It spoke about the social aspects as well. 1 billion, 1,200 kilowatt gas power plant to be built in the Western region, expected to bring down the cost of electricity by 20%. He refers to all of that. So, questioning is he oblivious of this?
Well, I would like to present something on the expenditure side, and that will help answer the question that you've just asked.
Okay.
So if you look at the total expenditure of government as programmed for the first quarter of the year, so program expenditure was 158 billion Ghana cedis. We ended up incurring an underspend of 20% of that, which is 127 billion. So 127 billion spent against a program expenditure of 158. So there's some element of underspend, which then probably accounts for why there have been some delays. And the underspend, it's a function of some things you consider positive and negative. So on the positive side, we underspent on compensation. We've always had that issue where compensation seemed to be the biggest expenditure on government books. So the underspend was as a result of something where we discussed this about some ghost names and all the issues in the Auditor General's report. So government's improved payroll control and elimination of ghost names helped us to save 2.4 billion. That's positive. The second point is on interest. We saved 6.9 billion as a result of reduced policy rate on T-bills, for instance. So government is borrowing, but it's borrowing at a much cheaper rate than we used to have in the past. So that represents a savings. The challenge on capital expenditure, which Doc said earlier, that we had an underspend of 40% on capital expenditure. So the ambitious capital program that we announced last year, how have you progressed on them? And obviously, Honorable Gideon Wako's village and the road in his hometown will be affected to some extent, to the extent that some of these program expenditure are not undertaken.
What do you mean when you say that the capital expenditure reached 22.2 billion?
So that's 22.2 billion spent against 36 billion for the first quarter.
All right.
First half of the year to say. So we underspent by almost 40%. So if we have spent the full 36 billion, then some of the projects that we are worried about would have been undertaken.
And Gideon's concerns would have been taken.
That's this.
Okay.
So yes, we've made some good savings on interest payment, which is positive because historically interest payment actually exceeded that of compensation at some point when we were going through the DDEP, before we were forced to do the DDEP. Compensation has always been a problem where we have ghost names, we have dealt with them largely. So I think the challenge now for government, which I think the Minister of Finance addressed it by telling us what they are seeking to do. For instance, the Accra-Kumasi Expressway, feasibility study is underway, and they expect to start the procurement process sometime this year, which is positive.
Yeah, but some people are concerned that you are putting 1.7 billion
in Bank of Ghana.
Yes, untouched, but there is need to spend now to fix the roads. It's going to take how long to get it done? And you want us to go through all these debt traps for all this while when the money is sitting there?
I would say there are some good aspects of it and maybe some concern that has been raised. The first is the fact that historically, some of our capital expenditures have not had earmark funds. We incur them and we have issues with contractors not being paid. For me, this is positive because you have a situation where the construction starts, it gets stuck in the middle of the way and there's no funding, which is the second positive thing because you will have to have some form of sinking fund for the debts that we are incurring for the program that we plan. So it's a positive thing in my view because a project starts and doesn't have to get to the middle before we start looking for funding. And I think that's a good thing. We should also look at the revenue aspect. So yes, there's been some control on expenditure, but as Honorable Gideon mentioned earlier, on the revenue side, we missed our target, albeit about 1.1%, which is good, but he mentioned 6% if you go into the details. I want to look at where we perform better and how we can improve that.
Right.
So there are some aspects of our revenue handles that we haven't done well historically. Property taxes. And the statement says that taxes on income and property outperform targets. 57.5 billion against 53 billion. So we kept introducing new taxes, not to mention e-levy others, forgetting that we had low-hanging fruits. How many times have you received property bills? Now property bills come to your home like ECG bills. That's an important development because we are focusing on what we have been taxing over the years, forgetting that they are low-hanging fruit. So we keep talking about widening the tax net, but this was a low-hanging fruit, property taxes, and we outperformed that. The second thing is also on areas around oil revenue and corporate income tax, like I mentioned earlier. If corporate income taxes are increasing, then it means that there's production going on. I think what we need to look at a lot more, it's on areas that we can improve. And I've mentioned, as my colleague mentioned earlier before, about online taxation, for instance. So if you look at the tax programs and measures, for instance, the first one is on the income tax. There's a comprehensive review of income tax legislation by 2027. Some of our tax laws and provisions are outdated. And in line with the principles of taxation, equity, certainty, fairness, one of the principles is flexibility. And the flexibility that we are introducing, for instance, is areas of reforming it to reflect the current situation. So we have increased the threshold for VAT registration from 250 to 750. 250 was many years ago. And today, a trader making 250 is still like someone in a shop, a container. You don't put that person through the administrative cost of trying to register for VAT. You have to increase that. So that's also very good. And I mentioned earlier excise duty reforms. And one of the positive developments is the 20% or proposed removal of 20% on excise duty on locally manufactured fruit juice, so that our local industries can compete with importation. Right. Then enforcement of Ghana card PIN as a sole thing, tax identification number. We have gone through the rigorous process of registering Ghanaians. Yeah. We should be able to tax them. That is a cost to us, but we should optimize the benefit of making sure everyone has a Ghana card. It applies in the courts, it applies in the bank. You need a Ghana card to do everything. Why don't we follow that up to ensure that everybody who has a Ghana card, any Ghanaian who has a Ghana card, is tax compliant? Elsewhere, it is mandatory. If you have worked with anybody coming from the United States of America, they know they have to file their taxes, so they are very mindful of wherever they go. That's what we should be doing, that any Ghanaian with a Ghana card is tax compliant. Then the last one is VAT collection mechanism for non-resident digital platforms. Like we mentioned before, there are people who are making money in Ghana here using online. How are you tracking them? Can you make business or make money from the United States online without being taxed? If elsewhere you cannot do that easily, then we should also look at it and make sure we are addressing the issue.
It becomes very obvious why you guys are not satisfied with your backgrounds and professions in the economy and everything, but you want to go and do law and do taxation in addition to it. Yes, confidential.
Yes. So my last point is on our flagship programs. Something that's always been the problem. My first comment is we've always had flagship programs. They start well and they don't end well. I will start with special presidential initiative started under President Kufuor. He had the cassava starch initiative. That's right. That brought Ayensu starch. We had the oil palm initiative. Right. Today, where are they, those initiatives? To date, recently, we've had one district, one factory, one village, one dam, etc. There are a number of problems with those initiatives, which doesn't make them successful. One is that we duplicate them. Right. We duplicate existing institutions and agencies. Why would you have a one district, one factory secretariat when we have a Ministry of Trade and Industry? They have all the data. They have all the resources to run it. We create a secretariat. So we spent about 2 years creating a policy and office initiative to run the department. Then we have, my entrepreneurship lecturer will say, 6 months of power play. The minister fights with the CEO of the secretariat. And then another 3 months of injury time after the fight. That's what the entrepreneurship lecturer says. We have to avoid duplicating the functions of various ministries by establishing these initiatives. It's instructive that the Women's Development Bank, they formally be incorporated this year in January. Okay. But we have to see that implemented. And we should not be duplicating. We should have agencies in business units, for instance, the Mahama Cares. We have the NHIS. We can still have the NHIS support Mahama Cares to effectively function. Same thing we are having with the 24-hour economy. Okay. My problem with some of these initiatives that they are expansive and so wide. Let's focus on sectors where we can make transformation happen. President Kufuor started Cassava Starch Initiative, and there was a factory supported or established to support that.
That's right.
24-hour economy. What are the key sectors that we are focusing on, and how are we making them function to optimize the benefit?
Oh, interesting. You're still here on Newsfile. This is your most authoritative news analysis platform, and here on Newsfile, as you know what we do best, we put Ghana first. My guest, Yawapia Latte, Fred Kwashi Awute, both are lawyers. Gideon Boako, they are lawyers, and also you know what they do that we don't need to announce. Gideon Boako is MP for Tano North and member of the Finance Committee in Parliament. Of course, he's an economist. He used to work in the office of the Vice President. This show is brought to you by the kind sponsorship of Bank of Africa, as strong as a group and close as a partner, MTN. Ashesi University, educating ethical and entrepreneurial leaders for Africa. Robert & Sons Optical Services, your comprehensive eye care service provider for 33 plus years. My Way Insurance, dial *165# on MTN to join My Way today. Syntex Tanks, it's strong, it's tough. Safari Valley Eco Park, bringing you closer to nature. Waylead, your trusted home builder. Bethel Dental, the smile starts here. Kel Charcoal Toothpaste, happy smile. Palladium Residences, live smart, invest better. Heritage Christian University, educating compassionate entrepreneurial leaders. And Abro Super Blast Insecticide, One Blast, total protection. My outfit, as always, is by Habils Couture. You can find them at Adjuringano, but go on their socials, just type Habils, and they will come up, Habils Couture. You can call them 0200 84 1988. They deal in the best of kaftans. Now, yes, Gideon, I saw that you were itching to speak already. So briefly, we're very limited time, in about a minute or two.
So
what do you have to say?
I think the common narrative...
And I actually had asked him some questions which he sought to answer, which questions were actually questioning your presentation.
So the common narrative around this table is that, yes, we need to ensure macroeconomic stability, but we should not go for fiscal prudence at the expense of expenditure and revenue. And that's why the minister, in his speech in Parliament, was even reticent in mentioning some of the expenditure and revenue figures. My friend was even talking about the expenditure and then the expenditure at the shooting. What the minister presented is actually not what is reflected in the tables. The minister presented expenditure and the shooting of 19.7% using the target of 158 billion. If you go to Appendix 2A, and that is what Parliament approves, Appendix 2A figures are higher than what the minister had stated. So in natural sense, the expenditure undercut for first half of 2026 is 26.2% and not the 19.7% that the minister put out. Samson, you see, the minister has the love and the penchant to look good and have good economic indicators, but that affects us. We need to ensure stability in the city. But when you ensure stability in the city and the dinner table is not stabilized, it is a problem. We need to ensure that the economic gains, that growth that we are having, is job-induced. Because a growing economy with unemployed youth is not growth. That is a factory for frustration. Okay? So whatever we are doing, we must ensure that the discipline that we are talking about is aligned with compassion, because lack of compassion can break society. And that is what the Ghanaian people want to see, that we have stability that is not just developed, but is also developed for the poor people. And it is important that as we are talking about all of these things, what happens to social safety nets like LEAP? What happens to school feeding program? What happens to students in UK and US on scholarship of the government of Ghana whose scholarships are not paid? If you are not able to raise the revenue and spend, you will look good on the books, but the Ghanaian people will suffer. And Samson, maybe
I'm sorry, but we have run out of time.
You cannot have green economic indicators when your social indicators in Ashai, Mamobi, and all of that are red.
Okay.
Green economic indicators must go with
Fred,
green
what would you say in 30
stability.
seconds as your
It's
concluding?
So important.
Okay, thank you very much. In my conclusion, experts, the minister mentioned that VAT non-compliance is about 60%. And for a developing country, having non-compliance of VAT while we are yearning for stability is not a good thing for us. And the minister's position of actually implementing fiscal electronic devices, which have been in the books since 2018, which is very laudable, for which we can. Then what I would say is that we shouldn't think that we are out of the difficulties yet, although we are hearing for stabilization. We are still within the borderline. So for that matter, all measures which the minister has proposed, I think when implemented, will yield some results. Thank you.
Thank you very much. You have to forgive us, but we have run out of time, and I had to do this to you because you understand us better because of this thing. Right. So Pia Latte is lawyer and partner, strategy and transactions and Africa infrastructure and capital projects leader, Deloitte Africa. Fred Kwashiaute is also a lawyer, vice president, Chartered Institute of Taxation, Ghana, and Dr. Gideon Boako is MP for Tano North and member of the Finance Committee of Parliament. This has been Newsfile. It's your most authoritative news analysis platform. I'm Samson Ladi Anyanini. Have a good afternoon.
Bank of Africa, as strong as a group, as close as a partner.
Where Duraplast goes, water flows.
PS Industries has introduced a new roofing system known as ColorLink Plus. Flamingo paint, simply superior. Syntax tank, are you strong? Are you tough?
Cherry Tree Properties. We develop spaces as though we were going to occupy them.
Welcome to a place where everyday living is reimagined, where space, movement, and community come together effortlessly. With thoughtfully designed spaces, modern facilities, and everything you need within reach, you don't just live here, you feel safe, comfortable, and at ease. Step inside Eden Heights and discover spaces crafted for comfort, style, and everyday living. And just when it feels right, you will know. Because this isn't just about finding a house, it's about stepping into a better way of living. Eden Heights, the height of modern living. Book a private viewing today.